Hello. I think I may have some information on the little boy that has no name.
Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Grizzly K. This is Grizzly True Crime and we are here for closing arguments for day 5 of this Teresa Black trial in Atlanta, Georgia. And this is a cold case. I say dating back to it's a 1998 cold case because it's believed that 6-year-old William DaShawn Hamilton died in 1998. But his body was discovered on February 26th of 1999. And for 23 years, no one knew who he was. And because of one tip from a lady called Ava McNeil, who knew him when he was, a kid, 4, 5, 6 years old. One tip when she saw an art rendering made by the NCMEC, and that was the lead that investigators needed to start tracking down his parents and to figure out who he was. And now his mother is on trial. I've put up a poll there. I might stop that poll soon. It's been going for a few hours now. So let me just quickly see what you guys said before we watch closing arguments here. Do you think the state has proven their case? I'm sure, closing arguments sometimes could sway your opinion. So we'll see afterwards what you guys think. Do you think they've proven their case? 3% said no, not at all. 52% said yes for some charges, not for murder. 29% said yes for all charges. And 17% said not sure, we'll catch up. Okay, so thank you so much for voting. Really appreciate it. All right, I'm glad I started a little bit later because the live feed was very delayed today. They were very, very late. So it's good that we started later. So if there's any breaks or anything coming up, hopefully we can just skip through that, okay? If you haven't yet, please subscribe, become part of this community, like the video and share it. Hashtag Teresa Black Trial, hashtag William DaShawn Hamilton. Okay, welcome mods, patrons, members, everyone. Thank you for everything that you do. On Patreon, I'll be sharing a little story of what I've been up to today. Okay, so you can, I'll send you a little mini podcast. And what else? I think that's it. If you don't know anything about this case, look for clues on the screen. Also, look in the description box. It should all be there for you. And also, you can watch the trial prep day. Okay, then you should be all caught up. Okay, are we ready? Let's play this. This is the court day starting. I do also want to say, for replay watchers, especially newbies around here, there's a couple of comments that are like, you talk too much, lady. If you don't like a talking head, this is my channel, then you need to go where there isn't someone talking. And there's many places for that, okay? You could just go to the news, watch the mainstream channels, and no one will bug you with talking. Over here, we're here for commentary and to discuss this as a community, okay? So with all the prep done now, let's watch the court day 5. Okay, here we go.
Everybody gets a pass, including me.
If I need to boost it, I will.
We're here and we are ready to go forward.
Seems like we might
Ms.
need
Potter, you have the opening and concluding
Stand by.
portions of the argument.
Yes, Your Honor.
Let's boost it.
Okay, you may begin.
Too soft. Okay, here we go.
Good morning, ladies and gentlemen.
Good morning.
I want to first thank you all for your time. You have been very attentive during this trial, and we threw a lot of evidence at you. And we were very observant in watching you take your notes. So I wanted to first thank you for your time. When the state first began this case, when the state first talked about the human remains that were discovered near the intersection of Clifton Springs and Clifton Church Road in a wooded area in Atlanta, Georgia, DeKalb County, we refer to those remains as Child Doe. During the evidence, you heard that these remains were stored in a DeKalb
Cameraman, we want to see the lady. We want to see the lady. I'm like, where is she? She's like all the way off screen there.
County Medical Examiner's Office for over 20 years. And at some point in time, Dr. Gowit and his colleagues gave these remains a name, and he called them Dennis. Because there were so many people coming to the medical examiner's office to review these remains in hopes of trying to discover who these remains belonged to. So they named him Dennis. And then you also heard during this trial that these remains did in fact have a name. That these remains mattered to some people. And that these remains were sought after by individuals who loved him, who was steadfast in trying to find his location. And through the work and the love of Ava, we were able to determine the names of these remains were William DaShawn Hamilton. These remains had a name. These remains were loved, were cared for. And we want to make sure that these remains will be now known as William DaShawn Hamilton. We want to give him that respect that he deserves and the respect that is warranted. You see, there were individuals that loved him. But there was one individual that failed him. And she failed him miserably. And it was the one individual that was supposed to love him unconditionally. And instead, she discarded him as if he was trash and left him in a wooded area to slowly decompose to the point where no one is able to discover who he was for over 23 years. Ladies and gentlemen, that's what happened here. And when we all first spoke with you during jury selection, we told you that this defendant was presumed innocent unless until proven guilty, right? And I'm going to get to that, but I wanted to make sure that this is the individual we're going to talk about today. This is the individual, William DaShawn Hamilton, that was left in the woods. This individual is the reason why this defendant is standing before you today. Innocent unless and until it is proven guilty. And that presumption is only there until it is overcome by evidence. Evidence that you heard from the witness stand, evidence that you heard through exhibits, through videos. Once that presumption is overcome by evidence, then they are no longer presumed innocent. That is done. It is gone. The state has the burden of proof in this case. And that's a burden that we take on. We have the highest burden of proof within our judicial system. And we have to prove each and every material allegation of this indictment beyond a reasonable doubt. Now, what is reasonable doubt? That's important. The burden is important in this case because it tells you how you can review the evidence and make decisions based off of the evidence. So let me tell you what reasonable doubt is. It actually sounds as ironically as it says. a doubt for which a reason can be given. It's based off your common sense and reason. So during jury selection, we were telling you, we understand that your experiences cannot be left outside. Your experiences make you who you are, and it helps you to learn what is common sense and what is not. So we didn't expect you to leave your outside experiences at the door. We expect you to use those experiences so you can be able to make inferences and reasonable deductions when you are reviewing the evidence. What reasonable doubt is not, it is not any possibility. There are millions of possibilities that anyone can come up with. The question is whether or not there is a doubt that is reasonable that goes to the essential elements of the crime to which the state has to prove. It is not vague and is not arbitrary, and I do not have to prove to a mathematical certainty. I don't have to say this is 100% guilty, this is 99% guilty. That is not how reasonable doubt works. It's not to a mathematical certainty. Your job as jurors is to not search for doubt. We asked you during jury selection, can you be fair? Can you be impartial? Because that is what a juror is a fair and impartial juror who is honestly seeking the truth as to what happened to William between December 1st, 1998 and February 26, 1999. That is your duty, and that is what the state is calling upon you to decide in an impartial and a fair manner who wants to know the truth about what happened to William between December 1st, 1998 and February 26, 1999. So I want to ask you, when we speak about reasonable doubt, let's think about it this way. Is it reasonable that this defendant, who knew something was wrong with her son William for a few days, who observed the following symptoms of her son over a few days: lethargic, weak, tired, gagging, didn't want to talk, didn't want to walk, didn't want to do anything?
So the prosecutor's all the way on the side of the screen there because the cameraman's being very careful not to show the jury, which is great. Okay, thank you all for being here. I really appreciate it.
Is it reasonable for a parent to see these symptoms for a few days and not seek medical attention? I submit to you the answer is not. Parent may see one symptom, maybe two, but you have 7 different symptoms up here that this child is experiencing over a period of few days, and that came from this defendant's mouth. And she failed to seek medical attention. And because of that, William is no longer here with us today. The state also has to prove venue. Venue is the location where we can say the crime happened. We're here, venue is DeKalb County. We have to prove that this case, that venue relies in DeKalb County. I want to let you know that if a dead body is discovered in this state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. I submit to you, and I'm going to say it now, that the state does not believe that William Hamilton died in that wooded area and laid there for decomposition. I submit to you that William was driven there and dumped in the woods with his Timberland boots on, double knotted as defense counsel stated, and left there. We know he didn't sleep there from a plethora of reasons. But one that was very, very important was that canned bottle that had his shoe imprint in the wooded area? Is it common sense to believe that he slept on that canned bottle when he went to sleep that night? Because the intention of the canned bottle is that he slept. I submit to you that if he slept there, meaning that Teresa, this defendant, and William got off a bus and they walked to a location in the wooded area to get off the street and slept on pine straw during the cold, when she previously advised you that she slept on park benches, that she slept in the park and at bus stops, she's not going to go to a wooded area full of pine straw to go to sleep. And William's leg is not going to be so comfortable that his boot is sitting on a can while he's resting. So I submit to you that this body was dumped in this wooded area in our jurisdiction in DeKalb County, and that is where Bode lies. There's also another portion of venue that we have to prove as well. In any case in which it cannot be determined in what county a certain crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. So I want to talk to you about, I'm going to touch on briefly and I'm going to come back to it, but concealment of the death, right? She concealed it and she lied about it. She placed the body in a wooded area. She told you she either took a jacket or a sweater and she laid it on top of him, covering up his body. Concealment. And then she lied about it. She lied about it continuously over and over and over again. And the lie started at the very beginning. The lie started when she made that phone call to Ava from a payphone. And I submit to you that during her statement, she stated when she got here, she was living in the Decatur area. She used a payphone, and she stated that William was in a room with friends, and that's why Ava couldn't speak to her. But she told you all through her statement that she lived in the Decatur area, which is in DeKalb County. There's no area outside of Decatur, Georgia, that is not located in DeKalb County. And she told Ava a lie. She told Ava, oh, William, he's in the room with my friends. She just got to Atlanta. What friends she got? She don't know nobody. William did. And at that moment, she told a lie, starting a cycle of lies and continued the lies for decades. But the lie began in DeKalb County with Ava. So I have to prove that venue lies in DeKalb in reference to that charge as well. And I want to go ahead and kind of give you all a preview of that information as we progress on through the closing argument. So here's the location where William was found. And you heard from multiple witnesses that the body was located somewhere along this wooded area. There's a path, and you can actually see a vehicle right here. There's a path in which cars can travel within that wooded area. And here is an entire cemetery that ironically this defendant never saw when she told you all she slept there. And then she stayed there for a day or two watching over William as he lay there dead. She never noticed there was an entire cemetery there. And you telling this jury that you've been there for over 24 hours watching your dead son. So then, let's talk about her intent. I want to be clear. In order for the state to prove intent, which we have to do, I want the jurors to know that it may be inferred from proven circumstances by any acts or conduct. I can prove this defendant's intent through her actions, through her conduct. And in your discretion, you can also infer logical conclusions about her acts or conduct, and you can look at it and see if her actions or conduct results in the natural and necessary consequences of those acts. So, for example, this defendant gives her child some medicine, some acetaminophen and diphenhydramine, because there may be issues going on or because she needs him to sleep. And then he begins to exhibit symptoms from these drugs. And she tells you in her statement, I will give him anything I can find. She subsequently over-medicates him. You can draw the logical conclusion that that medication that was also found in his skeletal tissue, coupled with her statement that she gave him the drugs, without seeking medical attention, you can infer that the logical result of that conduct can result in death. Criminal intent does not mean the intention to violate the law. We don't have to prove that she intended to kill William. We only have to prove that her actions were prohibited by law. And her actions in her failing to seek medical attention for her son, knowing that he has these symptoms that he has been exhibiting in her care for a few days and failed to get attention, when she is now dealing with something that's outside her expertise, right? When you're sick, you got a cold, you'll take some medicine. And hopefully you'll take the prescribed dosage as notated on the medication. But if you don't get better, you don't continue to take the medicine. And as you continue to deteriorate, you won't not go to the doctor or seek any kind of medical attention to get better. That's unreasonable. Especially when you're 6 years old and you can't do it yourself. You have to depend on the person who took you from your family, who uprooted you, moved you to a new state, and that is the only person that you got to depend on. So at 6, he can't do it himself. And so this defendant, who is his parent, has the obligation to make sure the safety and welfare of her son is accounted for. And by doing so, when things of this nature happen, you need to seek medical attention. And if you fail to do so, the natural and necessary consequence of that action can result in death. You heard of testimonies from several doctors that at any point in time, when these medicines are in the system and there's a level where it becomes toxic, you can get medical care and you can live. But if you fail to do so, the consequence of your actions can result in death. So I don't have to prove that she intended to kill him, but I have to prove that she intended to not get him medical attention. She intended to not get him medical attention because she didn't. She intended to give him medicine. She continued to give him medicine, and he obtained a level of toxicity to the point where it caused his death. Intention, proven. She gave him medicine, it's in his system. She didn't seek medical attention, she told you that. Those are the two acts that I need to prove in reference to this defendant, not that she intended to kill. Witnesses came on this stand, and it's your job to observe their credibility. When observing their credibility, you have to gauge their manner, how they testify, their interest or lack thereof in this case. their means and opportunity of knowing the facts about which they testify, the nature and the facts about which they testify, the probability or improbability of their testimony, and their credibility as you observed it. This incident happened in 1999. Ava came to you all and took the stand. What did she gain from it by taking the stand? What did she gain from it by telling you what she knew? She told you several things, plenty of things about this case. William Hamilton, he testified. He told you, I tried to see my son on many occasions. She wouldn't let me. She even put a gun out on me when I came to see my son. I just wanted to see my son. I wanted him to be a part of my life, my family's life. His grandmother Margaret told you, I love my grandbaby. I would have done anything for him. I would have taken care of him if given the opportunity. I took care of 6 of my grandchildren at one time. What did they have to gain from their testimony other than just telling you the truth? What do they get the benefit just by coming here and speaking to you? And if you determine that these individuals are credible, then you can believe what they say. And I want to be very clear that
Marie says, why do they hardly show her? Do you mean Teresa, the defendant, right? Because at the moment, the cameraman is tracking, of course, the prosecutor, but making sure not to show the jury. So that's why we're seeing that pan action happening. As for, I don't know why they don't show Teresa too much. Here and there they do. And they will, I'm sure, today as well. They do sometimes, right? But I get it, not that much.
Whenever one witness testifies and you believe them, that establishes a fact. The state does not have to prove or corroborate any witness statement. If you determine the facts from one witness and one witness alone to be the truth or to be a fact in this case, and that is it. I don't have to corroborate any additional facts to make it true. So when Ava told you that she met Teresa in 1995 and they hung out every single day, got up in the morning, smoked a little weed before they went to work, got off work, she played with William every day. And then Teresa ups and leaves and comes to Atlanta, Georgia. She calls her one time and never calls her again. One time in Atlanta and never calls her again. That is a fact. And that's a very, very important fact. Because when you are best friends with someone and you talk to them every single day, and that best friend loves your child, and it's unquestioned, undisputed how much Ava loved that child. She loved him so much that she was the only one who fought for him, and they weren't even biologically connected. Teresa trusted Ava around her child. Ava asked every day, where's my baby? How my baby doing? Even when she witnessed this defendant abuse her child, she told you on 2 different occasions. She punched him in the chest one time, and then the second time when he didn't like her food, she threw him across the room. Those facts were given to you by Ava and Ava only. If you determine those facts to be true, then they are facts, and that is enough. Evidence. So there are 2 kinds of evidence, and it's very important. One does not outweigh the other. They are weighed equally. You have direct evidence, and then you have circumstantial evidence. Direct evidence is what you heard from the witness stand. Exhibits. Things you can see. Things you can hear. Videos. Interviews. That's direct evidence. Circumstantial evidence is a proof or set of facts and circumstances that tend to prove or disprove another fact by inference. Jurors, you are allowed to make logical inferences based off the facts that you learned in this case. Inference number 1. Gary Harris, individual who lived on Clifton Springs Road, who worked night shifts, staying at his brother's house, came here after the Olympics. He was resting in his bedroom because he lives with his brother at the time, and he was sleeping in his nephew's room. He hears something around 3:30, 4 o'clock in the morning. He hears a door. He looks out of the window, sees the inside of the car light on, and sees another door closed. And then it drives off. And he tells you that was so odd because nobody is out in the woods at 4 o'clock in the morning over in this area. And it's cold. And it's so cold that the next day he wanted to go investigate and see what was going on, but never went out there. And then subsequently, the news came on and the remains were found in that wooded area. You can make logical conclusions that based off that series of facts, that it was highly probable and highly likely that's when William's body was getting dumped in the woods. You have the ability to make those inferences through circumstantial evidence. There is no legal difference between direct evidence and circumstantial evidence. The law does not require any higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. You can base this whole entire case off circumstantial evidence, and you can find this defendant guilty beyond a reasonable doubt. You see, the test is whether there is sufficient evidence or whether evidence is sufficiently convincing to satisfy you that the elements have been, that the elements of each additional, the material elements of each additional count have been proven beyond a reasonable doubt. Whether it be direct evidence or circumstantial evidence, it doesn't matter. It's evidence. There is no rule that either direct evidence or circumstantial evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact. And that question of facts lies with the jury. There are 6 counts in the indictment. These counts form the issues to which you are to decide here today. You have count 1, felony murder, which is count 1 as well as count 3. Count 2 and 4 are cruelty to children. Count 5 is aggravated assault, and count 6 is concealment of death. I want to speak with you first in reference to count 1, felony murder. There are 2 ways the state of Georgia charges murder, right? You have malice murder, which is not being charged here today, and you have felony murder. Now, malice murder is the typical murder that everyone knows. A person who commits malice murder has the intent to kill. They pick up a gun, they point it, fire, pow, shoots an individual, they die. Or they take a knife and they deliberately stab an individual and that individual dies. They have the intent to kill. And that is malice murder. Felony murder is totally different. It's not that, and that's not what we have charged this defendant. Felony murder is that when someone causes the death of another person by committing a felony. You commit a felony, and as a result of that felony, someone dies. So count one is charged that this defendant did commit the death of William Hamilton, a human being, by failing to seek medical treatment for Will. The failing to seek medical treatment for William is the basis of the cruelty to children count. So that is the felony. So the cruelty to children committed a crime ultimately resulting in the death of William. Count two, the cruelty to children, just to reiterate, did maliciously cause William Hamilton, her child, cruel or excessive physical or mental pain by failing to seek medical treatment for William Hamilton. The essential elements of cruelty to children are as follows: maliciously caused, cruel or excessive physical or mental pain to a child under the age of 18. Count three is also felony murder. And count three is that this defendant did cause the death of William Hamilton, a human being, by administering a substance or substances containing diphenhydramine and acetaminophen, also known as Benadryl and Tylenol. Again, for felony murder, cause the death of another by committing a felony. The felony in count three is also cruelty to children, but it's a different count. Right? It is count four. Did cause cruel or excessive physical or mental pain by administering a substance or substances containing diphenhydramine and acetaminophen. So, I want to speak with you in reference to maliciously caused. Because malicious seems like a really, oh man, I maliciously attacked someone. That is not the legal jargon or the legal definition of malicious in this case. Malicious is not ill will, it is not hatred. We're not saying that she hated Will. Disconnected, sure. Love, questionable. But we're not saying that it was ill will or hatred. Malice is the intent to cause pain without justification or excuse. Willfully doing an act while aware of the strong likelihood that pain may result. Dr. Jackson told you all that he was a toxicologist, that he received 2 samples of skeletal muscle from DeKalb County Medical Examiner's offices, and he tested that muscle for any therapeutic and illicit drugs. And during his test, he discovered that it was 93 micrograms per gram of acetaminophen and 2,000 nanograms of diphenhydramine. It is clear that those drugs were in William's system, and Dr. Jackson told you that they were administered at least shortly before death. He cannot tell you the dosage, whether it was a lethal amount of dosage or a level of toxicity, given the fact that he only had that sample. He didn't have any other factors. He was not aware of any symptoms the victim was experiencing at the time. So we know for sure that William was in this defendant's care and those drugs were in his system. You can now infer that this defendant gave him those drugs. Knowing that he is now experiencing these symptoms, she continues to give the drugs. And she tells you that he can't walk, that he can't talk. When someone can't walk and can't talk, it is logical for you to infer that that is painful. And it then carry on for a few days. It becomes cruel. That is malice. The fact that she gave these drugs, observed these symptoms, and allowed him to continue to suffer, that is the maliciousness of the cruelty to children count. And as he suffers continuously without getting the medical attention, that is cruel or excessive. I don't have to prove both. I just have to prove one or the other, cruel or excessive. So however you determine it, whether it be cruel that a 6-year-old suffers continuously and continues to exhibit these symptoms that his mother sees and fails to get him attention, that's for you to decide. For a person who can't walk, who can't talk, who is gagging, who doesn't want to do anything, it's physical pain. And William was 6 years old at the time of his death. Those are the elements, the essential elements that the state has to prove, and the state has proven to you in reference to the cruelty to children count. And because he dies as a result of the diphenhydramine and acetaminophen in his system, that's how we get to felony murder. He dies because he has these drugs in his system. He's exhibiting these symptoms, and this defendant doesn't get him medical treatment. And because of that, he dies. That's how we get to the other felony murder. Count 5 is aggravated assault. This is the count where the state feels they have proven beyond circumstantial evidence that this defendant assaulted William with an offensive weapon. Offensive weapon can be anything. It's unknown to us at what type of weapon was used. But I submit to you this. It's undisputed that William had a fracture in his zygomatic bone. Dr. Gower referred to it as the jawbone. So I'm going to refer to it as the jawbone because zygomatic, I said it 3 times, it's not going to come out right. The jawbone is fractured. And each and every medical expert that came into this courtroom and testified tells you that it is a possibility that fracture could have been a result of blunt force trauma. No one could rule it out, not even a defendant's expert. In fact, she conceded that there was a probability that fracture could have been a result of blunt force trauma. What was also telling about that same fracture is that there were no gnawing marks, no scratch marks, no clawing marks from animal scavengers. There were on other parts of William's skeletal bones, but none where that fracture was. And that was very important. That was very important information provided by the anthropologist, that there was no gnawing, no scratching of that part of the bone. So therefore, we submit to you that bone being fractured was not a result of animal scavenging. Ava told you, as she watched her interaction with Teresa and William while they were together every day, there seemed to be a disconnection. This defendant was not connected to William. She had 2 incidents where Ava observed where she struck William. She punched him, and then she pushed him one time just because he didn't even like what she cooked. And this was before he died. And he died at the age of 6. And she hit a kid who was no older than 6 years old because he didn't like her food. Margaret Hamilton told you that there was a period in time when this defendant was not around William. And when she came back into his life, she had some concerns. She had concerns about the welfare of William. And that is telling. You know what is also telling to me? That I hope you all recognize as well. Throughout everything you heard from this defendant's statement to that witness stand, I never heard anything, including her statement, that she loved William. She never said it. Not one time. She was concerned about herself and saying, I didn't do anything wrong. I didn't know what to do. Not once did she say, I loved my son. I submit to you.
The court reporter is raising her brow there. What? I wish we could see the defendant's face now when when the state prosecutor is saying that, right?
She may have struck him, just like she did on the previous occasion. Caused that fracture. He's sick. He dies. She has something to hide. Dumps the body in a wooded area, in a location that she's not familiar with, not known to be around. She got on. And what's even more ironic about the disconnection between her and William is that on his first birthday after his death, she was at the DMV getting an ID card. The first birthday of William's murder, she is getting her ID card down at the DMV. That's the level of disconnection this mother had for her son William. The last count on this indictment is concealing the death of another. What the state has to prove is that this defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. We charge this count in two ways. You see here it says, did unlawfully conceal the death of William Hamilton, which hindered the discovery of whether William Hamilton was unlawfully killed by leaving the body of William Hamilton in a wooded area and about lying about his whereabouts. The law is a little funny, right? Let me tell you about that little word "and" in that indictment. You see, it really reads "and" or. And means or. Right? I don't have to prove both. I just have to prove one or the other. I have to prove that she concealed his death by either leaving the body in a wooded area or by lying about it. We've proven it both ways, but I still just want you all to be familiar with how the law works and explain it a little bit to you. Leaving the body in a wooded area. She tells you herself, I left him in the wooded area. Off the street, we walked up. She tell you he was sleeping for the night there. I humbly disagree. But nevertheless, she laid him in a wooded area. She also told you that she either took a jacket or a sweater and she covered him up. That is very important because now you're covering up the body, further concealing the death of the remains. And it's in her statement. And if you didn't hear it, you have every opportunity to ask to listen to it again. That's totally your option. If you need to hear it, just let us know. We will happily play it for you. We don't have to play the entire portion of the interview. We can only play whatever parts you need to hear. But this defendant told you that she laid that jacket or sweater, either it was hers or something William had, laid it on top. Wooded area in a location where she's not familiar with, nowhere near William is from, no family nearby, and she left. And that body laid there until it was discovered by Mr. Parker and Mr. Carter, the two grave diggers, on February 26, 1999. She also lied about it. I'm going to tell you again the conversation she had with Ava. When she got to Atlanta, Ava told you all it was roughly about a week. A few days had passed. She felt she was at a payphone because she could hear the change dropping. And at that time, Ava knew William wasn't with her. And this defendant also confirmed that by saying he's in the room with my friends. And then Ava never heard from her again until she ran into her in Charlotte. At this time, William is long dead. William was dead when that conversation was made. Because, think about this. Your best friend, you talk to every day, at your house, every day. And in an instant, no contact. None. Logical inference in that, knowing that Ava loved William, asked about William on that phone. She couldn't stomach it. She didn't call her anymore. Either way you put it, whether you consider it concealing the death by putting William in a wooded area, covering him up with a jacket or a sweater, leaving him there for the maggots, and then lying to Ava, and then continuously lying to Ava because Ava continuously asked where was William. She never let up, and thank God she didn't, because now William can get the respect and justice that he truly deserves. We would have never figured out who he was, and she would have been successful in concealing that death. By the time law enforcement found the body, it's fully decomposed, we couldn't even tell if it was a boy or a girl. We couldn't even tell the color, nationality, nothing. We don't even make assumptions because he had on some Timberland boots that were double knotted and some boys' underwear. Ladies and gentlemen, quite honestly, that's almost how you conceal a death. But for the fact that you have a best friend who just so happens to love your child more than you. Ladies and gentlemen, I'm getting ready to sit down for a second, and then defense counsel is going to come up here. I'm going to suggest that he's going to tell you that this may have been an unfortunate mishap, that this defendant was young, that she didn't know what to do. But I disagree. She made a conscious decision in every action and in her conduct. She made a conscious decision to leave Charlotte with no family here in Georgia at 18 years of age, got on a bus and brought William here when there were multiple people more than willing to care for William until she got on her feet. But she didn't want that. She didn't want them. She didn't want William with any of his paternal relatives And one of the reasons was because William Sr. had another child that he just so happened to name DaShawn. She gets here. She gets a job at Pleaser stripping. And she takes all kind of drugs under the sun, whatever they give her. Marijuana, whatever's in the pills, cocaine, didn't matter. And she has a 6-year-old son here with her. She then begins to medicate him. He gets sick. And she made a conscious decision to continue giving him the medication. And she makes a conscious decision to not get him help when he so desperately needed it. Those are not mishaps. Those aren't, oh my goodness, I knew something was wrong and I didn't do it, but I shouldn't be held responsible. No, she is responsible and she needs to be held accountable. And my co-counsel is going to come up here after the defendant gives you his closing arguments. And she's going to give the final remarks. And she's going to ask you to do what justice requires. And she's going to ask you to return a verdict of guilty in all counts of this indictment. Thank you.
Okay, who's ready for the defense's closing arguments? They get 2 hours aside. I don't think that was 2 hours, was it? No. That was only about an hour or so, right? Just less even. That was good. They get 2 hours aside. So I wonder how long the defense will go on now. We shall see. I'm asking you in the chat, who was the most impactful witness for you? And for me, I mean, I named 3. I'm asking you, who was the most? And I'm like, okay, Ava, Teresa's ex-husband, and Dr. Gowett, the forensic anthropologist. Forensic, is that what he was? That guy. Remember the cool doctor? Yeah. Okay. Janet says, can I hire her to do my closing arguments if I ever need? She is awesome. So thank you all for being here. If you're wondering why are we behind the live feed, we're doing that for a reason, because yesterday the judge said that they would start at 9, but they started around 10, and then said that it will be 2 hours aside of closing arguments. And then she talked about a lunch break, and then I think jury instructions. So I'm not too sure why the lunch break has to happen in between that. I don't know. We'll see how the rest of the day goes, but I didn't want to like have us sitting through that and waiting. Maybe we could teleport through that if we're lucky. So thank you for being here. That's why we also started late today. Just like the other days, it helped us get through coffee breaks and lunch breaks in a second instead of 90 minutes or whatever, right? Okay, so Be Kind Tiger, maybe that one? I think that one, yes. Right, now let's listen to the defense's closing arguments. So this defense attorney is very good, so I would assume it's gonna be a good closing argument. Let's hear it.
Yes. All right. We're going to take a very, very quick break just to switch over to the electronics.
There's the break.
So step back to the jury room. We'll break right back.
There's Sam Welty. Here's Mr. Welty. Okay. Let me just get everything ready, and then we're going to teleport right through. I'm just going to change the banners for you, because now it's the defense's time, right? Okay. So let's see what happens here. There we go. Okay, so they said a short break. We go forward. Look at it. This is the beauty of starting late. Yeah. Okay. Ooh, he's getting ready. It's like, all right, let's go. Let's see how it goes.
All right. Mr. Bode, ready?
Mr. Honor, thank you.
All right, you may proceed.
Ooh, that cough, man. Shame.
Lieutenant Quigley sat in that interview room in Phoenix, Arizona, after hearing Teresa's entire statement, after hearing what the interviews were in Charlotte, after reviewing the case file, and he said it plainly, this isn't murder. This is a case where the state doesn't look at the obvious conclusion in front of them. This is a case where the state doesn't have any evidence of what happened in DeKalb County, Georgia in 1999. And they know that. So, to distract you from that, they need you to hate Teresa. They need you to think of her as a detached mother. They need you to think of her as someone who doesn't love William. They want you to feel those emotions so strong that you lose track of your job. Because your job is to look at actual evidence or lack of evidence, to use that to decide this case. There's a massive gap in this case. The gap is any evidence about what happened in DeKalb County. They can't fix that. So they bring you a complicated web, and they hope if you add a little bit of each person from Charlotte up together, you'll feel enough that you won't care. All of the witnesses from Charlotte, one after another, told you nothing about DeKalb County. At most, taken together, the witnesses from Charlotte told you that sometimes a single teenage mother was rude, seemed distant, were times when William was dirty, were times that William wasn't allowed to go out and play. These witnesses clearly loved William. William's death has changed them forever. For 25 years, they've dealt with grief, concern, worry. But ultimately, they just lost him in 2022 when they learned of his identity, when they learned that he was gone. And in some ways, this grief is still fresh. And now, since 2022, Teresa has been named in this indictment as a murderer. She is the cause of their sorrow and grief, according to this document. They see her through this lens. They can't see it any other way now. It is a filter how they view Teresa and how they view their memories of William and how they view Teresa and William's relationship, and they can't help it. But it's a reality that they've had sorrow and guilt for so long, and now there's someone to blame. I'd like to begin with Ava McNeil. Again, Ava McNeil clearly loved William. She seems like a good person from all accounts. But her memories are now warped by this bias, a confirmation that she thought Teresa did something, and now the district attorney in DeKalb County has agreed with her, reinforced that opinion in her. It has changed the way she remembers things. Ava.
Oh, really? Is what I have to say right now. I'm feeling snarky. Snark tank is filling up. How about you?
Spoke about Teresa withholding gifts and items from William. She told you that the neighborhood raised money and bought William $150 of candy. This is a murder trial where DeKalb County, Georgia is trying to convict this woman of the most heinous crime anyone can think of, and this is the evidence they brought you. That a mother in 1997, 98, we don't know, didn't give her child $150 of Halloween candy. I don't know how much candy it was. That seems absurd. Whatever, there was candy. Maybe Teresa was embarrassed by this. That the neighborhood has now taken it upon themselves because they think she's a bad mother and raised money and given candy. Maybe she didn't want to have all this Halloween candy at once. Is not giving your child Halloween candy evidence of murder? Of course not. There's other things too. That he was dirty when some people bathed him. Or that he was a bedwetter and some mornings he didn't have a bath before going to the babysitter's house. Are these things evidence of murder? If they are, the headlines should read, "Mother convicted of murder for not giving her child Halloween candy." That's ridiculous. We all know that's ridiculous. These things are not evidence. But it's all the state has. So they hope, if we pile enough of it together, that, sure, one thing's not enough, but also somebody said his feet stunk sometimes. So when you add that in, they want this web to now say, see, we told you. See how she was as a mother? Now they need you to make a leap that she's a cold-blooded murderer. That's ridiculous.
I won't interrupt her all the time. It's closing arguments. We want to hear it all, but I'm like, whoa, dude. Obviously, it's signs of neglect, and then you just put it all together, plus dosing him with Benadryl and Tylenol, which was in his skeletal muscle, and the way that she just left him out in the woods. I mean, who else left him out there like that then, you know? Sure.
Ava said that she was with Teresa and William every day for 4 years. She never said she saw physical abuse. And we need to talk about this. She said that she saw nothing that would make you think she would hurt him. The state says that the Charlotte witnesses can tell you the state of the relationship between William and Teresa. That's the state of the relationship. The person who was there every day said she never displayed anything that would make you think that she would hurt him. That's the state of the relationship. The 2 times that she was remotely rough with him, the state just told you what Ava said. And it's up to you to remember what Ava said. The state used the words abuse, punch, threw, and struck. That's not what Ava said. Ava said once she kind of shoved him in the chest, but it didn't hurt him. And another time she pushed him in the chair, but that didn't hurt him either. She said she didn't call defects, despite knowing she could, because it wasn't serious like that. She did not have a concern about her being violent to him. But the state just sat here, right where I'm standing now, and Miss Jackson told you that that was proof of abuse, and that she punched him and struck him and threw him. They lied to you. That is not what Ava said. But they need it to be. Because a mom in 1996, 97, who pushes their child in the chest when he makes a complaint about what's for dinner, does not get you to where they need you to be. It doesn't get you to, that's the same type of woman that would come to DeKalb County and murder her child in cold blood. We all know that's true. So they need it to be abuse. They need it to be struck. They need it to be hit and through. But that's not what Ava said. She said that both of those instances were not a big deal and were not serious. She didn't even tell you that she spanked William or that she whipped him or hit him or anything like that. Nothing. No one ever told you, despite other people saying that they bathed William, they ever saw any marks on his body, because there were none.
And why did everyone else bathe him and not his own mother?
Ava told you what else she saw in the 4 years that she knew William. She saw William's father once. In the 4 years she knew William, she saw William's father once. We heard about Teresa being angry when William's father's family dropped him off late. Of course she was angry. William's father has no involvement in his life. Teresa sets boundaries and rules, and they get broken. William's grandmother, Margaret Hamilton, she said she thought it was because it was a school night and Teresa wanted them home early. Either way, whether you think Teresa was justified or not in her emotions or how she felt, is that evidence of murder? Of course it isn't. And taken with everything else, it still doesn't add up to the leap that they need you to make. The state brought you witness after witness that will say, I would have taken William if she had asked me. And I still don't know why they kept trying to insist that, because it cuts against the theory. If Teresa didn't want to be a mother anymore, why not give him up? Why not give him up to family that has watched him before? If her whole thing is she wanted to be rid of him, and she wanted that so badly to not be a mother anymore, why not just give him to a family member? It's because it's not true. Teresa didn't want to be rid of him. Teresa did want to be a mother. She was moving to Georgia, and she brought him with him, because that's her son. We heard from several other people from Charlotte. First one was Miles Boyce, that I want to talk about next. The guy that drove her to the bus station. He says that they were friends. Teresa came over to his house several times. Let William go over and play with his sons. No abuse, no concerns, no isolation of William. This is the state of their relationship in Charlotte. Montequellian Davis, the babysitter, she said William was dirty when he lived with his grandparents. This was before Teresa's mother passed away. That's what she said. She said Teresa would let William come over for the weekend. When Miss Davis asked if William could come over, Teresa never said no. No physical abuse, no neglect, no concerns. That is the state of William and Teresa's relationship. Finally, Wanda Hamilton. She said that Teresa would reach out for help, and they would help her. She wasn't isolating him. No abuse, no neglect, no concerns. That is the state of their relationship when they were in Charlotte. That's the real state of the relationship. And that is what the state wants you to base your verdict off of. The state wants to make it look like William was a happy-go-lucky child before Teresa came back into town. When Teresa got in his life, he was quiet and sullen. And that's not backed up by the timeline or the evidence in this case. Witnesses have said that. And I think that goes to show the filter and the warped view and the bias they have against Teresa, because we have evidence from Ava. She was there for 4 years with him. William passed away when he was 6. So we're talking 2.5 on. She's there from then. The beautiful child that Ava knew, Teresa was his mother. The child that liked to laugh and play with trucks, she raised him. The child that could read an encyclopedia at 5, that is her kid. Ava's fondness of William all happened while he was living with her. She didn't come back into his life and he shut down. That's not what Ava told you. I'd like to talk about the father, William Hamilton. He wanted to get on the stand and act like all of his absences as a father were because of Teresa. Said that he was available to take William when Teresa went to Atlanta. That's what he said. And that's not true. The judge told you exactly when he wasn't available. He wasn't available from October 14th of 1998 through March 3rd of 1999. The exact same time frame we're talking about in this case, when Teresa went to Atlanta. 2 months before she left, he is not available to help. He's never been available to help. He then started talking about child support. He sat on the stand under oath and told you that Teresa was taking out child support payments from his check after William had passed away. We then heard a statement. And we learned he just sat there and lied. His statement was to the same DeKalb district attorney, the investigators that came to talk to him said, yeah, she tried to get child support from me, but it didn't do any good. I didn't have any money. So it's taken a leap from 2022 to 2024. Now it's that she was getting money. This whole thing is a lie. The state found a manager from a burned down strip club in Atlanta, Georgia, to come talk to you. They brought you school records from William from North Carolina from 1998. They found a responding officer, Mr. Gaskew, who hasn't been a cop for 20 years. If Teresa filed for child support after William passed away, that would have been the first piece of evidence they brought. Either from the clerk of court, from William Hamilton's bank records, they would have moved heaven and earth to get that evidence. It doesn't exist because it is all a lie. He then said that one time, because he always tried to go see his son, one time he got there and Teresa pulled a gun on him. That's a lie too. Because if you want your son, and you want visitation with your son, and you want contact or custody of your son, and the child's mother has now pulled a gun on you, you call the police. That's how you get access to your son. You say, hey, his mother's not letting me around, and now she's pulling guns on me. I'm just trying to be a good father. He didn't call the police because that didn't happen. He just made it up. He seems like, and I'll grant him this, he seems like he may have gotten his life together as a father. He seems to be involved in his children's lives, and I'm happy about that. But he wasn't involved in William's life. And it's not because of Teresa. And you probably feel some guilt about that now. This man lived 12 minutes down the road. In a 4-year span, he saw William once. I bet he feels some guilt about that. He could have tried to get custody. He didn't. He could have tried to get the court to impose visitation. He didn't. He's on the birth certificate. The state showed it to you. William Hamilton did not care about being a father to William. The state said in opening from the beginning that remains are not the only evidence in this case. You can take circumstances of the relationship between William and Teresa, like how she's treating him, and use that instead. The circumstances of the relationship, and this is what they bring you. Multiple witnesses who had no concerns about Teresa being violent towards William. This is what the state wants you to base your whole verdict on. And this is enough? What the Charlotte witnesses said? No way. We then heard from some witnesses from DeKalb County. First, we heard from Marie Dial. She was the day shift manager at Pleasers when it was open. The only thing they proved with Marie Dial is that Teresa at some point worked there. And we know that she worked there for a very short amount of time. None of the girls even knew her. She doesn't know when. We do know that she has to have a license to work there. We know that she got a license in Georgia on June 23rd of 1999. Now, stepping aside here, the state says that this demonstrates her disconnect, that she got a license on her son's birthday. If that's their argument, this represents the desperation of the state. If that's evidence of murder, and that's what they've got, there is nothing. But we know she got her license on June 23rd of 1999. This is multiple months after we know William's body has been discovered. There's no evidence that she had any license in Georgia before that. Officer McClendon told you that. There's no evidence of her having a license in North Carolina. We know she didn't drive. Again, this is easy evidence for them to get. If we can get people from the 90s, the manager at the strip club, we can't call the North Carolina DMV. It's because she didn't have a license. So she had no ability to work at Pleasers before June of 1999. The state wants this to be the smoking gun of this case. How could she have worked as a dancer at Pleasers if children are allowed? She must have drugged him in the woods, because we know that she was working as a dancer. There's no evidence that she danced while William was alive. I'm going to repeat that again. There is no evidence that she danced while William was alive. In fact, there's evidence to suggest it wasn't possible for her to dance while William was alive. Next, we heard from Gary Harris. He's the man who lived across the cemetery. He said at some point he saw a car and two people got in. That's it. Also, I think the state might have been surprised when he pointed on the map where it was, because it was well away from where William's body was found. He doesn't know who these people are. He doesn't know if they're men or women or race or what they look like or what the car looks like. He saw two people get in a car in the middle of the night and drive away. That's it. Maybe those people were dumping the couch that we saw in those pictures. Maybe they're throwing something else out. Maybe they're meeting up and doing drugs or something else illicit. I don't know. It doesn't matter. This is a trial for evidence and proof. And we have a man that said in 1999, I saw two people get into a car. That is it. We know that the police and medical examiner at the time were desperate for leads. They didn't have any. And Mr. Harris said that he called it in. So police obviously investigated Mr. Harris's lead. They obviously looked into this, and it went nowhere. This has nothing to do with this case. We heard from Ryan Van Sickle from MARTA. Again, I don't know why we heard from him, to be honest. I think the state may be showing you that Look how long it takes to get from the women's shelter to Pleasers to Clifton Church Road. But forgot that we don't have any evidence that she was, one, doing anything with the day shelter, the women's day shelter at that location while she was working at Pleasers. We have no evidence that that was while William was alive. And we have no evidence that she was going from Clifton Church Road to Pleasers or the day shelter. Those are 3 points on a map that could be from a year's span, and they want to show you she couldn't even get there all in one day. No one said she did, except them. No one said she was working at Pleasers when William passed away. In fact, there's evidence to suggest that's not how it happened. No one suggests, or no one told you in evidence that she was staying or going to the women's day shelter while she was working at Pleasers. She said she was going to shelters. They were downtown. We don't know where she went. We heard from Bessie Brown, a woman from Clifton Methodist. She says that she was never aware of homeless people living in those woods. I don't know why we heard from her. There was no evidence to say that Teresa and William stayed there for even more than one night. Bessie Brown wouldn't have seen this. But she's not evidence that, see, this woman from the church said that she never saw anybody. We're talking about one day in 1999 that she didn't see someone in the woods with no car parked out on the road. Of course she wouldn't have seen this. That's not evidence. We heard from Shirley Baker, who worked at Women's Day Shelter for a few years after William passed away. She told you that beds were limited in the metro Atlanta area. She told you that some women slept in the hallways of an office building. She told you that some slept outside of the shelter, in cars or otherwise. The state wants you to believe that in 1998, 1999, Atlanta had enough beds for the unhoused. There wasn't an issue. We all, as citizens of DeKalb County, know that it's certainly an issue even today. Everyone has their experience in life with this. We're talking about 1999. And Ms. Baker told you that beds were limited. We heard from Mr. Gaskew, first officer on the scene. Mr. Gaskew told you that there was no apparent attempt to conceal the body. The state makes a point about Teresa saying she put a blanket or a sweatshirt over him, or a jacket. Well, I don't know what she put over him when he passed, or if that was while he was sleeping. It wasn't left on him because it wasn't there. They told you about every piece of clothing that were in those woods. A jacket wasn't left on William. It was nowhere in pictures. It was nowhere when they had cadets come out and look at every inch of those woods. Teresa did not put a jacket or a blanket or a coat over William. We heard from Detective Harvey. Detective Harvey says that in 1999, he was not able to tell you how the child died. He can't tell you how the child died now. He said there's a juice can. You heard the stipulation. There was nothing in that juice can. There was no cocaine, like a crack pipe like Detective Harvey suggested. There was no Tylenol. There was no Benadryl. This was a juice can. And now, the state wants to say this couldn't have been his juice can because it was dented and his leg was on it. We know that his remains, his body, his skull were moved. Officers talked about that was in an odd position that they believed to be from animal scavenging. The fact that the juice is dented means that they didn't sleep there. It makes no sense. And if this is his juice, it shows that they did sleep there. You don't go to dump a body and bring a can of juice with you and dump that as well. That doesn't make any sense. Again, Detective Harvey told you that there was no apparent attempt to conceal the body. William's body was not partially buried. William's body was certainly not burned. There was nothing laid over him, branches, leaves, pine straw, nothing. It was sitting on top of the pine straw. Woody Hall, the medical examiner investigator, told you as well, no attempt to conceal the body. Mr. Hall was the first person that really started talking about animal scavenging to us. Listen, I know you probably had no idea when you got your jury summons that we would have to talk about animal scavenging of a child's remains. And I'm very sorry that that is true. I'm very ready to be done talking about that as well. I know it's hard to listen to, but we have to talk about it. Mr. Hall told you that the zygomatic arch was never found. This is because it was taken by an animal. They sifted through soil all around the body. Mr. Hall said they would go down 18 to 24 inches through the ground. They were able to find teeth. They were able to find finger bones, tiny bones, because they sifted and looked. That bone wasn't there because that bone was carried off. We know that the skull was moved, certainly from the body, at least 10 feet. We know that the jaw, the mandible, was also found several inches from the rest of the skull. There was damage all over the mandible. There was damage on this corner of his jaw and this bone right here. This is animal scavenging. All of the evidence here points to this. There is no evidence that points anyone to the fact that this is something different. It's a possibility. We can't prove it. It's a possibility. That's as much as they get. And that's what Dr. Tice told you. Meredith Tice came, the forensic anthropologist. She said this can absolutely be animal scavenging. She was part of the team in 2013 that said this damage was post-mortem. I want to be clear. That 2013 University of South Florida team didn't say, could be either. They gave an opinion. Dr. Gallup told you this was their opinion, and we showed it to you on the screen. They gave an opinion that this damage was post-mortem caused by animal scavenging. That's in 2013, when they had the remains sent to them, along with the pictures. That was their opinion. And Dr. Tice was a part of that team. She signed that report. She signed it. She also said on December 8th of this year, after viewing the skeleton again, that this was post-mortem damage. She didn't even mention perimortem, ante-mortem, pre-mortem. This was post-mortem. On December 13th of this year, 5 days after publishing one report, she comes back and says, it is possible this damage was due to perimortem trauma. It is possible. And she cites the lack of scraping specifically on this bone, on the zygomatic arch. Again, she says she brought in this new idea because she finally looked at the pictures. These are pictures that her professors were sent. These are pictures that the team was sent at the University of South Florida. These aren't new pictures. These are pictures they've already looked at. Dr. Gallup told you that he sends pictures. Of course he sends the pictures. He doesn't just tell people what's in them. He's hiring somebody to review the case. He sends the whole case. We also learned that the skeleton that Dr. Tice viewed had been altered from the clay reconstruction. And there was clay in cotton filling in the gaps on that mandible in other locations where the bone was no longer there, where the bone was gone from gnawing. Dr. Turner told you and showed you the pictures from the scene and the pictures from Dr. Tice's review. There was clay on the ends, covering up even more fraying of the end of that bone. We're not talking about fraying of a bone on his hand. We're talking about a bone that goes right here. And this is where the bone was broken. Come on. But the state wants to rest on, it's possible. It's possible that it was around the time he died or before he died. It's possible. The state doesn't get to convict people with, it's possible. It's a little bit of inside baseball, but in the criminal law world, it's possible theories are used by defense attorneys who don't have a very good case. Because normally, in a normal trial, evidence is presented to support a theory of guilt. And what defense attorneys do is they say, I need to come up with, in this evidence, an alternative. So they come up here, and with every witness, they say, but you can't say that it's not possible. And of course, because our world is messy and things aren't certain, witnesses say, well, yeah, it's possible. And they come up here in closing arguments and they say, they didn't prove it beyond a reasonable doubt because this is possible. The state...
I'm taking you guys with me to the kitchen quick. I'm gonna go get coffee, okay? I need it. It's very cold and we need energy. They've got 2 hours per side. The state took about an hour and the defense can use the full 2 hours if they want to. So I'm not too sure how long they go, but I think it's over an hour, okay? It's been about 40 minutes or so now. All right, so thank you so much all for being here. I'm still here, okay? I'm not going anywhere. I'm just quickly getting coffee.
It doesn't get to convict people with, it's possible. That's because the burden is on the state. I think it can probably be very easy sitting through a week of trial, especially if this is a first one and you don't have experience with this, to imagine that these two tables are the same. That the trial is a competition between two tables, the state and the defense. And it's about which table brings you the best story, which table you like more, or which one you believe more. It's natural. I think this is how we deal with things in life when we're faced with two options. We watch a football game and it starts 0-0, and the two teams see who can score the most points. This trial is not about who scores the most points. We are not the same. On this table rests the burden of proof, and it's heavy. It's not about who scores the most points in your eyes. It's not about who you like more. In order to shake that burden and convict Teresa, they have to prove each and every element. That burden's not on that table. That's how our system is designed. This table doesn't get to live on it's possible. They have to prove this indictment. They have to prove it beyond a reasonable doubt. I want to talk to you about what this is. The judge is going to read you the law. It's a big packet of all the laws that she's going to read you. But reasonable doubt, it is simple. It's a doubt that you can give a reason for. I'm going to say that again. Reasonable doubt means a doubt that you can give a reason for. If you're looking at this evidence, and your mind is wavering about what really happened, if you are unsatisfied with the evidence, unsettled. That is reasonable doubt. If you have these doubts, you are required to find Teresa not guilty. Now, the state's going to rely on the fact that they don't have to prove this case to a mathematical certainty, and that's true. But they do have to prove it to such a certainty that you don't have any possible reason to doubt their story. Their theory, their case, needs to leave you so satisfied that you can't think of a reason to doubt their case. This is a heavy burden. And they are going with, it's possible. The judge will tell you that even if you have a grave suspicion that Teresa is guilty, that's not enough. This is a heavy burden, and we're nowhere close. Teresa told you what happened. In her statement, she said, "I know I shouldn't have left, but I didn't hurt him." That morning, Teresa woke up to every parent's worst nightmare. The person Teresa was the night she went to sleep is not the same person she was when she woke up that morning. She is a person who has lost a child. The agony she felt paralyzed her. She stayed with him all day, praying for a miracle that he would wake up, but knowing that he was gone. Eventually, she began to walk, and it was the only thing she could bring herself to do. Teresa Black, as you have witnessed her in court, and this woman sitting in this chair, is not the woman that's on trial. The person on trial is a 21-year-old single mother.
There she is.
She found herself alone in Charlotte.
Okay. They're showing her now. She appears to be crying.
Her father had moved away. Her mother had passed away. She wanted a change. She wanted a different life. So she moved to Georgia with her son. Things didn't work out like she thought they would. She ran out of money quickly. She was scrambling to keep her son safe. She didn't want to sleep in the city streets with him. She couldn't keep him safe around other people. So she took the bus to a safer location. They were eating out of dumpsters. And she gave him some medicine, over-the-counter medicine, because he didn't feel good. She didn't know what was happening to him any more than any of the doctors who testified in this trial know what happened. One morning, he doesn't wake up. She sits with him all day. By the time she starts walking, in her mind, it's already too late. She's afraid, people will think that she killed him. She's afraid people will think that she hurt him, and she knows she didn't. As days go by, she starts to get stuck. Now, no one will believe her. Everyone will assume the worst. This 21-year-old makes a terrible decision. It starts to snowball. It starts to get out of her what she thinks, I can't go back now. At some point, she goes from not telling anyone to being faced with a decision. And she lies. She gets back to Charlotte. People ask her directly, "Where's William?" She makes a decision and she lies. The lies start to compound. They begin to snowball out of control. And then 23 years later, she's chained to a table, and 2 cops start asking her questions about the nightmare she's been living with for, at this point, over half of her life. She doesn't tell the truth right away. And you all can hate her for this. You can hate her for these lies. That is not what Teresa Black is on trial for. The state's entire case has been an attempt to make you hate Teresa Black. And I think that was not a difficult thing for them. We as a society don't like a mother lying about their child passing. We as a society don't like a mother not reporting a child's death. We don't. And they need you to feel so strongly about that, and feel so strongly about these emotions that you look past the science. Because without emotions, this case is nothing. Without the emotional spin that they want to put on this case and make you feel, this case is nothing. It's time to talk about what Teresa is really on trial for. Teresa is being charged with 6 counts. 2 of them are felony murder. Felony murder is 2 things, 2 prongs. It is that you caused the death of another by committing a felony. So it is a felony happened, and that felony caused the death. It's important that that felony caused the death, and not just that a death occurred. Each felony murder count is therefore paired with a second felony. In this case, she's charged with felony murder in 2 different ways. The first is count 1. In count 1, she is charged with felony murder for causing William's death by committing cruelty to children by not seeking medical attention. So in count 1, she's charged with causing his death by committing count 2, that cruelty to children. So, to find her guilty of this count, you must find beyond a reasonable doubt that she committed cruelty to children by not seeking medical care, count 2, and that this act is what caused William's death. This is count 2. This is that cruelty to children count. For failing to seek medical treatment for William Hamilton. I want to talk about the elements of this. Because to find her guilty of 1, you need to find her guilty of 2. Here's how that thought process goes. To find someone guilty of cruelty to children in 1st degree, you must find that that person maliciously caused cruel and excessive physical or mental pain to a child under 18, and here, by failing to seek medical treatment for William Hamilton.
I mean, he's got some good points, right? But we know where he's going to go now, right? He's going to say, but she did seek medical treatment because she got in Benadryl and Tylenol. I think he's going to say that, right? I'm like, oh, here we go.
Malice, the state talked about it briefly, but malice is an intent to cause that pain. I want to be very clear with that. This is not an intent to not seek medical care. Well, we know she intended to not seek medical care. That's intent. Malice means an intent, and that action was intended to cause that pain or willfully did that while aware of a strong likelihood that pain may result. For this, to find her guilty of cruelty to children for not seeking medical treatment, you have to find that Teresa didn't take William to the doctor because she wanted him to experience this cruel and excessive pain, or she didn't take him to the doctor while aware of a strong likelihood that he was going to experience cruel and excessive pain. Next, we have count 3, our second felony murder. This is the felony murder that is attached to count 4, the Tylenol Benadryl cruelty count. Again, to find her guilty of felony murder, count 3, you must find, beyond a reasonable doubt, both that she is guilty of cruelty to children by giving him diphenhydramine and acetaminophen, and that this act caused William's death. This is the cruelty for the acetaminophen and diphenhydramine. Again, maliciously caused. So you must believe that Teresa Black, and you must believe the state proved it beyond a reasonable doubt, that Teresa Black gave William acetaminophen and diphenhydramine maliciously with the intent that he experience severe pain or injury, or did it aware that there was a significant likelihood that he would experience a severe pain or injury. Count 5 is aggravated assault. For this, you must believe that while William was alive, she hit him with some object in the face. The language here is that she caused serious bodily injury by striking said victim in the head. So you must find an assault to another person with an offensive or deadly weapon. Count 6 is concealing the death of another. To find her guilty of concealing the death of another, you must find that she did something to conceal his body, which hindered the discovery if he was unlawfully killed, and that this happened in DeKalb County. So, the fact that it did take time for William's body to be found does not automatically satisfy this charge. Teresa, you have to believe beyond a reasonable doubt that Teresa concealed, that she did something to conceal this body. Now, I'd like to talk about all of these in turn. I'd like to start with the cruelty to children for not seeking medical care. Again, the state must prove beyond a reasonable doubt that Teresa did not seek medical treatment either on purpose, so William would experience severe pain, or she did it on purpose knowing that by not seeking medical treatment, he would suffer severe pain. For this charge, we should look to the doctors. They are the ones that provided any medical evidence about what was happening with William. We heard from two experts, Dr. Gallup from DeKalb County and Dr. Turner from St. Louis. And they both told you the same thing. Teresa told police that William was gagging and lethargic. Both experts knew what Teresa said William was suffering from. They knew what his symptoms were. And they told you several things that would often display with the same symptoms. Pneumonia, or food poisoning, or a cold, or the flu, or a virus, or an infection. They also told you about things that could have happened suddenly. It could have caused William's death. Things that Teresa wouldn't have seen coming. Things that Teresa wouldn't have had a knowledge of a strong likelihood that it would cause pain. Things like an undiagnosed seizure disorder, undiagnosed diabetes, heart conditions, brain conditions, dehydration, sepsis. These are all things that they've experienced as medical examiners. These are all things they have experienced as doctors. They said that it could be two things at once. He could have had a cold. He could have been tired because he didn't eat that day. And something unforeseen could have happened that caused his death. The doctors do not know what happened to William. Dr. Gowett told you that he had over 40 doctors look over this case. From the time William was identified until now, he's had 40 doctors review this case. They don't know what happened either. How is it fair for the state to expect you to know what happened? Both of these felony murders require causation. You committed this specific felony which caused the death. I want to ask again, how is the state expecting you to know what caused William's death when 42 doctors that we know of don't? No one knows what happened. And remember, this is not about looking back in hindsight, that Teresa should have taken William to the doctor, and we only know that because, well, it was serious enough that he passed away. It's not about looking backwards. It's not about what would have been best. The state has to prove Teresa didn't take him to the doctor in order to cause him pain intentionally, or that she refused to take him to the doctor while being aware of a strong likelihood that severe pain would happen. That's cruelty. The doctors don't even know if there was severe pain, much less if Teresa knew anything about it. Ms. Jackson brought up something at the beginning when she was talking about reasonable doubt, and I feel like I need to point this out. She said, is it reasonable for a parent to not take their kid to the doctor? I don't know if it was as an illustration of reasonable doubt or what, but the standard here is not, we find Teresa guilty because a reasonable parent would have taken her to the doctor. That's not the standard here. It's, did she do it with malice? That's the standard. With so many potential causes, that could happen like that and cause a child to pass away, a parent has no idea their child is in any danger of receiving any significant pain. They would have no idea they needed medical care. Let's look at what Teresa saw. Her recounting of William's symptoms is the only recounting we have. It's one of those times that the state discounts Teresa's statement until she says something they want or need, and then they believe that part. The only thing we have about William's symptoms are what Teresa told us. We have nausea, causing him to experience some sort of gagging, and we have acting lethargic. Now, Ms. Jackson stretched that out a little bit, saying there were 7 symptoms that he could no longer walk or talk. She didn't say he lost the ability to walk or lost the ability to talk. It's that he didn't want to get up. He didn't want to talk. He was lethargic. He was tired. This is every virus a kid gets. 6-year-olds get sick all the time. And this is what it looks like. Gagging and feeling lethargic is what we have. Dr. Goward agrees with that. This could have been a cold. This could have been a virus that didn't kill him. We don't charge parents for not taking their kids to the hospital when they're gagging or feeling tired. That's ridiculous. And that's what we have here. We have the state looking in hindsight. Well, this child died. It doesn't matter. It doesn't matter for the malicious intent required by the statute. It doesn't matter. We can't look back and say this was serious because he died. We have to look at what Teresa knew and intended to do before he died. Counts 3 and 4, cruelty for the acetaminophen and diphenhydramine. Here's what we know about these two drugs in this case. When given a toxic dose, these drugs can be dangerous and cause death. So, how much was William given? We do not know. We have no idea. Dr. Jackson told you he has no idea how much of these medications William had. Dr. Gowett told you he has no idea, that comparing skeletal muscle to dosage or blood is comparing apples and bananas. Dr. Turner told you the same thing. It could have been a toxic dose. It could have been a therapeutic dose, meaning the correct dose for a child of William's age and size. It could have been an underdose, meaning not enough medicine to even do any good, much less harm. A therapeutic dose and an underdose would not have any ill effects on William. It would not cause pain. It would not cause toxicity unless, like Dr. Gonzalez told you, William had a genetic liver disorder where a therapeutic dose could have been deadly. And if that's true, Teresa's still not guilty because there's no strong likelihood that giving an appropriate dose of Tylenol is going to cause severe pain. So all the doctors agree that we have no idea what dose William received. The state wants you to say that there is proof beyond a reasonable doubt that he received a toxic dose and that Teresa did it all on purpose. She intended for him to feel the pain with that Tylenol. No doctor is ever able to say how much of those medicines William received. And the state wants you to pick. They want you to say, despite getting no evidence of it, we say beyond a reasonable doubt that he received an overdose of these two medications. Their pharmacist, Dr. Gonzalez, said, well, these symptoms are consistent with toxicity from these two drugs. Yeah? They're also consistent with everything else that Dr. Gowett listed out. We went on and on. Yeah, I would expect those symptoms from that. That means it's also consistent with pneumonia and consistent with a cold. It's still no more evidence. When your symptoms are gagging and feeling lethargic, it's consistent with so much. No evidence here points in any direction of the dosage that William received. That's reasonable doubt. Right there. When you're back there and you're deliberating, and you said, did the state prove beyond a reasonable doubt that William received enough Tylenol or Benadryl that would have caused him excessive and cruel pain, mental or physical? The moment you say, well, he could have had a trace dose, and this is the same, would be the same exact result, then that's done. That charge is done. That's reasonable doubt. And you're not making that up. I'm not sitting up here saying, it's a possibility, though. I'm saying the doctor sat right here and said, I can't tell you which one it was. That's reasonable doubt. We have a trace, a therapeutic, and a toxic. We have no evidence to suggest which one's which. We have no evidence to suggest this is what caused William to die because his symptoms are consistent with so many different things. That's reasonable doubt. Ms. Hodder's cross-examination of Dr. Turner, she spent quite a while with Dr. Turner asking her to read medical labels, medicine labels. These are all medicines that Ms. Hodder said she purchased herself, and she went to the pharmacy during trial in 2024. She was asking a lot of questions about medications that doesn't provide us anything. All of her questions on that cross-examination. And how do we know that? If she had real questions that she wanted to ask about these medications, she would have asked those questions of her own witness, the pharmacist. Because Dr. Turner didn't provide any different opinion on these drugs than Dr. Gowett or Dr. Jackson. She said, when I asked her questions, it could be toxic, it could be therapeutic, it could be trace. She did the same thing. She didn't say something outlandish apart from the other doctors, but Ms. Hodder got up and went for half an hour asking her questions about these medications. Why not have your pharmacist answer those questions? Well, because she wasn't looking for any real answers when she did that. She wasn't looking for anything that would help you. She was trying to score points with a dramatic cross-examination. Because the truth is, Dr. Turner or her own experts, pharmacist, toxicologist, medical examiner, they don't know what dosage William received. Also, she didn't ask any questions about what was available in 1999. That would have been a question for the pharmacist. What drugs were available on the shelf in 1999? Her own expert that she flew in from California to come talk to you about drugs. He's been doing this since 1980. We don't know what the dosages were then. Not that they matter, because we don't know what he received. We don't know what the labels said. We don't know what section of the pharmacy they were in. We don't know if there was children's medicine that had both. We don't know if it was a lozenge or anything. They didn't ask those questions because they didn't want real answers. They wanted drama. They wanted to put Dr. Turner on the spot, make her read directions and labels, and pretend that it's proof that a medicine says keep out of reach of children, that should put Teresa on high alert. Every medicine says that. This was all smoke and mirrors. And it's another example of the state not giving you any evidence, because there isn't any. It's not that they would choose to not give you evidence. It's not that they would choose to instead have to have a dramatic cross-examination. It's because that evidence doesn't exist to convict Teresa. Before we move on from these 4 counts, the murder and the cruelties, I'd like to remind you of what Dr. Gowett said in his testimony. It is the last thing I asked him. No evidence to call this a homicide in 1999. No cause of death. No evidence to call it one now. Dr. Turner said there was no evidence to suggest this was a homicide. There's no evidence that points them in that direction at all. There's no evidence that points them in the direction of William died because his mother maliciously didn't seek medical treatment, or that William died because his mother maliciously overdosed him on Tylenol or Benadryl. There's not even evidence that pushes them in that direction over other options. That's reasonable doubt. These are experts in their field. Rely on them. And they're not my experts. Dr. Turner was mine. We called her in. We wanted to give you an outside opinion, somebody that didn't work in this case. But Dr. Gowett is the medical examiner in DeKalb County, called by the state. and he cannot tell you how this child died. And the state wants you to ignore that and say, yeah, but his mom was rude in Charlotte. So we're going to ignore it. Yeah, his mom didn't give him Halloween candy, or his mom pushed him in the chest twice. So we want you to ignore that anyway. Well, yeah, his mom lied after he was dead. So forget what Dr. Gowett, Dr. Jackson, Dr. Gonzalez, Dr. Turner say. Because she lied about it to police when she was handcuffed to a table. That's the leap they want you to make. Count 5 is aggravated assault, and this is the most ridiculous charge in this indictment. But it illustrates that the district attorney, they're not truth seekers like Investigator McClendon says they are. From the very beginning, there were signs of animal scavenging. That is what the experts believed when they looked at it, and there was no evidence to say it wasn't. Woody Hall was the first to mention it. Skull completely detached and dragged over 10 feet away from the rest of the body. Again, I hate to keep talking about this. I hate to keep having to pretend William is those bones. When he was so much more than just that, but we have to talk about it because the state has indicted her for breaking one of them. William's jaw was also separated from the skull, and it had damage all over it. We talked about the bones that come under your cheekbone when you open your mouth. Those were damaged. The balls of the jaw, those were damaged. The corners of your jaw, those were damaged. The nasals, those were damaged. The zygomatic arch, that was damaged. We're talking both sides of his face. He was missing other bones. He was missing a rib. He was missing fingers. He was missing, I think, a tooth. Why not charge her with injuring those? There's just as much evidence. The only evidence here is that a bone was broken. So why not charge her with hitting him in the ribs, too? A rib had come detached. There is no evidence to suggest that Teresa caused this injury by striking William with an offensive object. It's complete speculation. It's complete guess. The only person, again, that said anything different than animal scavenging was Dr. Tice when she said it's possible it was before he passed. She said that on December 13th of this year. Said because when she viewed the pictures, there was no scraping or furrowing, despite it being everywhere else around that bone. Again, these are the pictures that she viewed, her team viewed in 2013. And she signed her name to it. She still can't say that it's not animal scavenging, just that it's possible that it happened before he died. The only thing they've ever been able to say is that it's possible. And they don't get to use it's possible to convict someone. This charge is ridiculous, but it is important. It's important to illustrate what the DeKalb County District Attorney is willing to do. They will ignore the science, even from their own experts, to get a conviction when they want one. At the very beginning, Lieutenant Quigley said he was brought into this case. The DA was really excited about this new lead. Forget truth-seeking. They want another chance to get Teresa. They have a broken bone, so they looked at this indictment and said, throw another one on there. We'll see if something sticks. They have to prove this beyond a reasonable doubt. The best they can ever do is ignore the experts that say, looks like animal scavenging, jump straight on to the one person that says it's possible, and then jump from there to get to reasonable doubt is to say, yeah, but she pushed him once in the chest. She pushed him into a chair. See? It goes from it's possible to beyond a reasonable doubt because of the things that Ava said weren't serious and not a big deal and weren't abuse. This is not how our system works. That's not truth-seeking. Finally, I want to talk about concealing the death of another. I'm going to guess this count has been in your mind the entire trial. On its face, this count seems like the only one the state has provided any evidence for. Yeah, it did take a long time for someone to find his body. That must mean it was concealed. The truth is, they have not provided any additional evidence above any of the other counts. To find someone guilty of concealing the death of another, you need to find that they concealed it, that they hid it, or that they attempted to conceal it. And then the second prong is you must find that that did hinder the discovery of whether that person was unlawfully killed. If you believe that Teresa woke up and William was dead in those woods, and she is not guilty of concealing. If you believe that's a possibility that you can give a reason for, and your reason is there's no evidence pointing otherwise, or that's what she said, if you have a reason to say that that's what happened, then she's not guilty for concealing, for leaving him in the woods. Again, they have to prove that she dumped him there. They have to rely on Gary Harris. They have to say that was her and some accomplice, and they dumped him deep in the woods. Multiple witnesses have told you there's no apparent attempt at concealment. Woody Hall, Officer Gaskew, Detective Harvey. Again, there was no jacket laid on him. Another way that a person can be found guilty of concealing the death of another is if they lie or mislead about the whereabouts of a person who is deceased. And the problem with the state's case here, they have to prove that deception, just like they have to prove that act of concealment, they have to prove that deception took place in DeKalb County. So the 2 days worth of combined witnesses that told you about Teresa lying about where William was, when Teresa went into that gas station in Charlotte and they said, "Where's William?" and she said, "He's staying with friends or family," that is concealing. And that is concealing in Charlotte, North Carolina. They can charge her there. That's the appropriate place. That's a crime. Happened in Charlotte. Teresa Black said it happened in Alaska. Fine. Maybe you say it happened in Phoenix when she didn't tell officers right away. Fine. The only time we have Teresa talking about William's location was the phone call with Ava. Now this, Ava told you that it was a week after Teresa left. Investigator McClendon told you it was 3 days. So Teresa spoke with her once. For you to find Teresa Black guilty of concealing the death of another for lying about William's whereabouts in that one phone call with Ava, you have to believe beyond a reasonable doubt William was already deceased, and that phone call took place in DeKalb County. Now, the state's evidence is she said she lived in Decatur. Must have been Decatur. Couldn't have been Fulton. She said Decatur. That's not beyond a reasonable doubt. She told detectives, and they said, "Where did you live?" "Atlanta." "Where Atlanta?" "Decatur, I think." That's not her saying I was in Decatur 3 days after I got there, or 3 days after I left on a Greyhound bus. We have no idea where this phone booth was. We have no way to know where that was. She didn't say, "It's Teresa calling from DeKalb County." Certainly not. They have to prove beyond a reasonable doubt what county it was in. They showed you the special circumstances in that when there's evidence that a crime took place in more than one county, then either county is fine for reasonable doubt. There was one phone call. They didn't move that phone booth mid-phone call to multiple counties. One phone call where you have to prove beyond a reasonable doubt it was in DeKalb County. You have to prove beyond a reasonable doubt that William has passed away at that point. There's a special circumstance on criminal homicide that it's proper where the body was found, and that is for murder charges. That is because for murder, you have to charge the person in the county where the cause of that death happened. If you shoot someone and they get into a car and drive away and they die in a different county, and we don't know where that death happened or that cause of death happened, murder is fine to be where the body lies. That's not for concealing the death of another. There's no special rule here that has to happen in DeKalb County. So we are left with 6 counts, none of which have any evidence that point you beyond a reasonable doubt of anything. In fact, most of them rely on experts saying, I have no idea. When I sit down, I'm not going to be able to get back up and talk to you anymore. It's the way this works. Those are the rules. I have to just sit there. I'm going to be relying on you to remember the evidence with your own memories and your notes and the notes and memories of your fellow jurors. The evidence is not what I say it is, Ms. Jackson, Ms. Hodder. It's what you heard from the witness stand. But I don't get to come back up. So to talk about what their argument is going to be, I really just have to guess. Based on some of the questions that they have asked, I'm going to take a stab at it. I expect the state has crafted a very creative story. And I'll give them the benefit of the doubt that their story, they've crafted it in a way that everything they say is possible. But when they tell you what they think happened, I want you to watch the leaps that they take, the assumptions that they make. Ask yourself, when they make those leaps, what evidence are they basing this on? What evidence are they ignoring? Here's potentially a story the state could tell when Ms. Hodder gets up here. That the state believes that Teresa wanted rid of William. That she came to Atlanta, found William was a nuisance. Evidently, William was getting in the way of her dream of dancing at the Pleaser strip club. So every night, for her to go to work, she would drug William in the woods so he would fall asleep. She would leave him somewhere so she could go dance, and then she'd go after and pick him up. One night, William had a rare reaction to Benadryl, became agitated, so she hit him in the face, breaking his zygomatic arch. She, along with some unnamed accomplice that had a car, drove his body to the Clifton Church area and left him in the woods. She convinced this person, who she maybe knew for a couple of days, to help her dump a child's body in the woods, and this person has never told or was never found out. If that's the state's theory, or anything close to that, they are not truth seekers, they are storytellers. If that's the state's theory, and one they are asking you to convict a woman for murder with, they have lost sight of what evidence and proof means. Pay attention when they tell you what they think happened. I don't know what it will be. I made that up as a ridiculous example. But pay attention to how many guesses you have to make, how many leaps you have to make. Because in that story I just told you, You have to take the leap of she either knew someone in Atlanta or she met someone quick enough, formed a relationship that that person would hide a child's murder with her, that she came here and got a job immediately, despite not having a license, started dancing within the first 2 days, and all of this happened with William's death within the second day or so she had time to hide the body and then lie to Ava. Think of how many leaps you have to make for that. And again, it's possible. There's 100 stories I could come up with that are possible. We're talking about beyond a reasonable doubt here. I expect they're going to spend a significant amount of time telling you why Teresa's statement's not believable. Again, this is not about comparing stories. On one hand, you could believe what Teresa told police. On the other, we have the state's story, whatever it is. If you believe Teresa's story, then it's not guilty. If you believe the state's, beyond a reasonable doubt, then it's guilty. In the middle, where we don't know what happened, that's not guilty too. That's not proof beyond a reasonable doubt. If you don't know what happened, your job is done. The state of Georgia began their work on this case with a conclusion that Teresa Black was guilty, and they worked backwards, squeezing evidence into whatever story or mold that they are going to give you to tell a ridiculous, albeit exciting story. A story that the news would show up for. A story that they could have press conferences for. A story that people would watch. They were
I don't think that's what the press, media, all of us are showing up for. This is a cold case from 1998. Took 23 years to identify William DaShawn Hamilton because his mother sure lied and didn't tell anyone about it. That's what everyone's showing up for. It's just like incredible that Ava never, ever gave up looking for him. One woman out there who knew him between the age of 3 and 6, because he died when he was 6, right? And that's the last time she saw him. One woman never gave up. She searched every website, she called every hospital, she called everyone everywhere that she possibly could to try to find him. And eventually saw the art rendering with the NCMEC, the National Center for Missing and Exploited Children. The story is like, whoa, it's not because the state like told us a story, you know what I mean?
so set in their opinion that they didn't realize the full tragedy of this story. The truth about this case is that it is a tragedy. That this woman lost her baby. And that morning, laying on the pine straw in South DeKalb, this woman was alone and scared. And she messed up. She didn't tell anyone about William for a day. That day became a week. A week became months and years, and it became 23 years. But she never forgot him. She never stopped regretting that mistake. She left him, and she hates herself for it. She did not kill him. She did not hurt him. She loved him. I have represented Teresa for a long time now. And as attorneys do, I have done what I can do to protect her as my client. It has been the honor of my career to do that. I'm about to have to sit down. And I don't get to protect her anymore. I am handing Teresa Black's fate to you. And I'm scared. I'm scared that this case is emotional and you hate her. and that will be enough when it shouldn't be. I'm scared that you'll buy that it was possible. The state's story is possible. And you won't follow what reasonable doubt means. I'm scared because I don't get to do anything else for her. Those are my fears. I know they are ill-founded. You spent a week in this trial. I'm sure that this trial and this service will change you forever. But you have taken your jobs very seriously. You understand the stakes in the law and the facts. I know you will follow it. I know you will be truth seekers. And I know you will find Teresa Black not guilty of all 6 charges, because that is the truth. Thank you.
Thank you.
Wow.
All right, ladies and gentlemen, it is about 12:15. I was hoping to get through all of the arguments this morning, but we still have another hour or so to go. Do y'all want to break for lunch and come back?
This was an hour and
You
a
want
half.
to keep going?
Keep going.
Keep going.
Keep going, okay. All right, let me please take a quick comfort break, and we'll be back momentarily.
It's comfort break time, which means it's time for us to teleport. Here we go. We're going forward now. See that? Here we go. Are we ready for rebuttal? Okay. Oh, that was a weird sound. Sure, okay. No, that was just a comfort break, so it's now rebuttal time. Thank you everyone for watching this with me.
Okay.
Let's see what happens.
You're good? Okay. Ready, Ms. Potter?
Yes, Your Honor.
Yes, we teleported. Okay, so I gotta change the
Why can't
title.
the medical examiners tell you what the cause of death was for William DaShawn Hamilton? Why is that? The reason the medical examiners can't tell you the cause of death is because Teresa Black left his body in a secluded area in the woods, in a place where he had no connections, no family, where people didn't know him, to rot, to be feasted on by animals, to decay. Never lose sight of that. That is why the medical examiners cannot give you a cause of death. And the defense wants you to ignore that very important fact. They want you to forget your role as jurors and give up your duty to determine what happened in this case, and rely upon the experts who can't do their job because Teresa took evidence away from them. You heard from the medical examiner, the defense's medical examiner, that their job is very different from a juror's. They simply look at a medical cause of death. Is there evidence where they can medically determine what the cause of death is? You're a jury. And you have a very important role in society. A very important role. You don't just look at whether there is a medical cause of death. You look at everything. That's the whole reason you're in panel. That's the whole reason each of you are chosen. To look at the entirety of the picture. You look at the circumstances of William being dumped in those woods. You look at the medical evidence that the experts are able to provide you with. You consider the fact that Teresa lied over and over again. You consider her relationship with William before she moved here. And you consider her behavior after he died. And through that lens, you fulfill this very important role in our community. And you alone make a determination whether Ms. Black is responsible. The juror's role is the conscience of the community. You represent our values. You are a voice of our victims. It is a special role, and do not allow the defense to distract you and take away that privileged role that you have. Do not simply look at what the medical examiner was or wasn't able to do, because you can do more. You sat here for a full week of testimony and heard all the evidence that we were able to bring. All the witnesses that are still around to tell you what happened. And it is through that lens that we ask you to make a decision on this indictment and the counts for which Ms. Black has been charged. You don't need to hate Ms. Black to do that. We're not asking you to hate Ms. Black to do that. But what Ms. Black did is wrong. What Ms. Black did is criminal. All you need to do is to think about William and what happened to him and determine if she is responsible. And over the course of the trial, we have shown you that she is, through the evidence. And each little piece of the puzzle, in and of itself, is never going to be enough. Certainly not in a case where the defendant has destroyed evidence. But you're not required to give her a pass because she was able to do so effectively. You can take her actions into account. In order to determine this case, we need to walk through the evidence that you've been shown through the course of the trial. And let's do so in an orderly fashion. Let's start from the beginning. You heard that on June the 23rd of 1992, William DaShawn Hamilton was born to Teresa Ann Bailey, now Black, and William Harris Hamilton in Mecklenburg, North Carolina. You heard that in November of 1995, Teresa's mother passed away. You heard from multiple witnesses that between the time that William was born and her mother's death in November of 1995, that there was a 2-year period that Teresa was not in her son's life, that her parents were taking care of William, and that he was with them. In December of 1998, William is withdrawn from school. In 1995, when Teresa came back into William's life, she befriended Ava. And from 1995 until December of 1998, they spent a lot of time together. That's about 3 years. And you heard Ava's observation of that relationship. You heard her own observations of Teresa, the kind of life she was living. She had a good life in North Carolina. Teresa had a job. working for one of the biggest uniform distributors in the country, Earmark. She had a home that she could live in. She had family and friends. Her son's paternal side of the family was nearby. They had a whole network. And then suddenly, as you saw from the records, on December the 1st of 1998, with not even a full day's notice, she decides to leave Atlanta. She tells Ava she's going to Atlanta. She doesn't know anyone there. She doesn't have a job lined up. She's excited. Ava doesn't even believe her. And the very next morning, she's taking off with a duffel bag and her son, and she's leaving. We know William was withdrawn from school on December the 1st of 1998, before the holiday break started. Whatever it was that enticed her to Atlanta was something that happened quickly. It was exciting. It was interesting. And she pulled her kid out of school and she left right before the holidays, before the break. And you know he attended school up until December the 1st of 1998 because he attended 62 days of his first grade school year. We know school starts in the fall. And by December, he would have attended 62 days of school. So he was in North Carolina until he was withdrawn on December the 1st of 1998. He was in the first grade. He was 6 years old. Teresa was 21 years old. 21. This isn't a teenager. This isn't a child. This is someone who's already had to grow up fast, who is raising a son, who has a job, who's paying bills at her father's house, who's paying for daycare for her son. This isn't some foolish child. This is an adult. And this 21-year-old ups and decides to move to Atlanta. She moved to Atlanta for a more exciting life. She was bored with this humdrum life, living at her dad's, going to work at a boring job, not much going on in Charlotte, North Carolina. She moved to a bigger city. We know there's no way she uprooted and left all of this behind for nothing. She didn't just do this to go, move from hotel to hotel. She came for something. And she had some money when she got here. And you heard in her own statement that initially she was staying in hotels. You heard from Ava that she received a phone call from Teresa shortly after she got here, about a week. She made friends with some women. They were partying, and Teresa sounded intoxicated, and she didn't have William. The idea that this woman didn't have identification is ridiculous. So you're telling me that you've enrolled your child in school in Charlotte, North Carolina. You're paying taxes. You have a job. You're buying alcohol and hanging out with your friends, and you don't have identification? She comes to Atlanta. She's staying in hotels. You have to have identification to rent a hotel room. She's drinking. She's partying. Of course she had identification. That's absolutely ridiculous. Teresa came here with her North Carolina identification, and she started working in the club, and she made some friends, and she was having a good time. And she was 21 years old, and this was better than Charlotte, North Carolina. By February the 26th of 1999, not even 3 months later, William's body is found in a secluded area of woods in DeKalb County, in a location Teresa has no connection to. None. She's just gotten here. She doesn't know anyone. You heard from Ava that he was found wearing the clothes that he left in. William didn't make it long in Atlanta. He's wearing the clothes that he left in. Within a week, Teresa can't even put him on the phone to talk to Ava. She doesn't enroll him in school. His body was almost completely skeletonized. This is the late fall, early winter. This isn't a hot Georgia summer. These are cold temperatures. And you heard from the medical examiners that that would take 3 to 6 months. This poor child didn't make it long in Atlanta. And despite all the media attention, his case has gotten over 20 plus years. Outcries for help to the community, the newsprint, the television coverage, the podcast, the organizations, the tip lines. Not one person in Atlanta has ever come forward. Not back in 1999 when he was found, when they're holding memorials for this child, when the governor is offering rewards for information. Not one person has ever come forward saying they met this child, that they saw this child in Atlanta. And that's because William wasn't around very long. That's because William died shortly after he got here. He didn't even have a chance to go to school. He didn't have a chance to meet anyone. He didn't have a chance to make connections. The defense wants you to believe that Teresa came to Atlanta, fell on hard times pretty quickly, and chose a life on the streets with her son. Chose to go from parks to dumpsters for resources, shelter, when she had so much nearby. And it makes no sense. It's just not true. It's an after-the-fact fabrication, one that, quite frankly, was fed to Teresa by Lieutenant Quigley. You heard from the get-go. He gave her out. He gave her out. I wonder what you would have said if you'd been forced to explain on your own. But she took that story of a mother who fell on hard times that Lieutenant Quigley provided her like a life raft. And she used it. But the problem is it is discredited by the evidence, by the people who knew her and her circumstances. Teresa had a home in Charlotte, a nice home. You heard from Ava that the rent was paid up for 4 months when Teresa gave Ava the key. Teresa could have come home to Charlotte, to her home, filled with all her furniture, where William's bed was, where he could sleep at night, protected and sheltered. She had 3 brothers and a sister. She had a father. William's father's family, little William, lived in the same neighborhood. And you could tell they loved him. You could tell they wanted to see him. They had been seeing him until Teresa came back in his life. Slowly that changed. Teresa didn't want a relationship with William's father's family. She didn't want them in her life. It wasn't that they weren't there for her. She pushed them out. She had no interest in any relationship with them. But they were there. They were there. And they had expressed interest, and they continued to express interest. And they were options. She didn't choose to live that way in DeKalb County when she had all of this. William had his paternal grandmother, Margaret, who you heard took care of 6 of her other grandchildren at one point or another. His Aunt Wanda would have taken him. William had Ava. William had Ava. She told you herself that when Teresa decided to leave suddenly in this fashion, that she offered to take care of William until she got settled. And Teresa called Ava within a week of getting to Atlanta. And she never picked up the phone again. She could have. She could have easily called Ava. Ava and Miles both had cars. They could have come and gotten her and brought her home if that's really how she was living, if that were actually true. She would have called Ava and she would have asked for help. And Ava would have come and gotten her. Charlotte is not far away. Charlotte is not far away at all. And if it were true, which it's not, there were shelters in Atlanta at the time. See, unlike now, where we've basically gotten rid of all of our shelters, there were working, functional shelters in the 90s. I don't know if you remember, but that was right after the Olympics and the big push to clean up the homeless population for our big expose to the world. There were lots of services back then. And you heard about that shelter. You heard about that shelter from someone who worked there back then. It was a place where you could get breakfast, lunch, and snacks, where you could get medical treatment, clothing, help finding employment. They also worked with the night shelters in the area where there were multiple. There at the night shelter, you could have dinner. You could have snacks. You had a bed to sleep in. But there was a caveat. You had to show up by 5 or 6 p.m. You had to be there within the curfew. And that's going to be problematic for someone like Teresa, who's working in a nightclub. It's as simple as that. She can't make money and take her son to the shelter. It's one or the other, and initially, Teresa's priorities were making money in the nightclub. If all else fails, you heard that there is a task force set up. You don't make curfew. They've recognized that a lot of women who are suffering from homelessness and housing insecurity might be working these kinds of jobs. And they try to dissuade them from it. They try to help them with other resources. But worst case scenario, they have a task force set up that will work with you after hours and help get you shelter. Help you find a place to lay your head down. And if that doesn't work, you can sleep in the lobby. You can sleep in the lobby, outside or inside, protected from the cold. Ms. Black wants you to believe that instead she chose to ride MARTA for hours, just wandered into this random place in DeKalb County to which she had no connection, and just happened upon this maintenance path through the woods and laid down on the pine straw with her 6-year-old son to go to sleep for the night in the dead of winter. You heard from the neighbor across the street that at least a month or more, prior to William's body being discovered, that something very odd happened in those woods. That a car pulled in, that he heard a door close, and he realized that two people were getting into that car that had pulled way into the wooded area there in the cemetery, something he'd never seen before, and then took off pretty quickly. That was Teresa and someone else disposing of William's body, dumping him there in those woods, hiding the evidence. Teresa told detectives that she believed she was staying in the Decatur area at the time. She also indicated she was working at Pleasers all the way across town. That at some point she did utilize the Atlanta Women's Day Center all the way across town in the other direction. And I think it's pretty clear from the evidence that that wasn't until after William was dead. That wasn't until Teresa needed resources. It was when Teresa's life got out of control, when she'd burned through her money, when she didn't have a place to stay anymore, when she was using to excess, and she'd lost everything. That's when she turned to the day shelter. In June of 2022, for herself. She did it for herself. There's no connection to the Clifton United Methodist Church all the way on the opposite side of town again. These woods were a dump site. How do you know these woods were a dump site? She'd never been seen in the neighborhood. Bessie, who went to the church every single day, the church historian, has never seen Teresa. She never went to that church to ask for help. Certainly not after her child died. There aren't any businesses or homeless shelters in the area. Teresa, from her own statement, didn't recognize the name of the streets. Clifton Springs and Clifton Church. That's the intersection where these woods are located. Remember, Teresa didn't recognize those street names. But more telling than maybe anything is Teresa didn't realize there was a cemetery there. She didn't realize there was a cemetery there. You heard that in her own statement to the police. And the defense wants you to believe that when William passed, she laid there for a day or more, wandering around, not knowing what to do, and she didn't see this cemetery? It's nonsense. It's absolutely not true. She didn't see the cemetery because she was only there briefly at night to dump her child's body. She didn't know anything else about the area, and she didn't see anything else because it was late at night and it was dark. The defense has said over and over again that this child was well-dressed for the winter. This child...
I'm just going to pause here. This is not necessarily a graphic photo, so I think we can see this. It's a shirt, okay? But obviously, we know where it came from, okay? So just be prepared for what we're about to see.
The child was wearing a shirt. This is a shirt. It's not even as thick as a sweater. It is a thermal shirt. This is warm enough to play during the day in the winter with your friends on the playground. It's not warm enough to sleep in the woods at night. This child wasn't dressed to sleep out there like that, exposed to the weather. You're not going to choose the outdoors in December. maybe even January, dressed like that? I can only imagine how a child would complain, how uncomfortable that poor baby would be. It's just not true. This child wasn't brought there to sleep that night. The medical examiners back in 1999, when this child was discovered, were able to perform an autopsy. And they weren't able to come up with a cause of death. Because as we've already discussed, most of the evidence that they would rely on had been destroyed. The skin to show evidence of injury. The organs to look for disease or trauma. The blood to check for drugs, both of the legal and illegal kind. That was all gone, with the exception of some muscle tissue below the knee. But it wasn't all gone. All the evidence was not lost. In that muscle, through toxicological screenings, they were able to determine that this child had been exposed to acetaminophen and diphenhydramine. Acetaminophen and diphenhydramine, as you've heard, is common in over-the-counter medicine like Tylenol PM. There are some other brands that are exactly the same dose, the same warnings, the same everything. But it's typical of those nighttime sleep-inducing pain medications. It's for adults to assist with pain and to induce sleepiness. And we know this was administered shortly before his death. All the experts agree. What you know from this is that Teresa gave her son sleep-inducing drugs. She gave her son adult sleep-inducing drugs. You have to look at the big picture here. Teresa is new to Atlanta. She doesn't know anyone. She doesn't have money to pay for daycare. She admits that she wasn't using shelters in the beginning. That's in her statement. She was working at Pleasers. She could not bring William to the club. The manager told you that. Children were not allowed in the club. No one has come forward to say that they took care of this child while Teresa was working. And if you think there was someone that could have, I promise you, they would have been brought. If someone could say they looked after this child for Teresa, I promise you they would have been brought. In her statement, she said something very telling. When they are asking her, where would William be when you were using? She said, sometimes William was with her. Where was he when he wasn't? Who was looking after William when he wasn't with his mother? Tylenol PM. Tylenol PM or some other brand of the exact same thing was looking after William when he couldn't be with his mother. You heard that Tylenol PM has warnings. Do not use in children under 12. Severe liver damage. Overdose may occur. All over the packaging. And this is for adults. This is for adult medication. Tylenol and Benadryl haven't changed over the years since 1999. You know that. All of you have been using it all that time as well. That's ridiculous. We have known about the side effects and how to use Tylenol and Benadryl, and the human body hasn't changed and somehow started to metabolize it differently that would require new packaging. This is a known quantity. It was a known quantity back in 1999, and the drugs had the same warnings back in 1999. And I can promise you, if they hadn't, the defense would have asked about it. The defense would have asked those experts, and they would have brought you the different packaging. Because they have the same subpoena power of the state, the same right to examine witnesses and cross-exam and cross them as the state. They have no burden of proof. The burden is on the state. They can say nothing. But when they choose to exercise those rights and they don't bring it to you, that means it's not there. Because there was no change in the packaging. Now, there are children's formulas of these medicines, but you heard that they're packaged in separate medications. They're not going to be in the same product. So what you'd have to believe is that Teresa, who says she doesn't have a place to stay, who's living in parks, who can't afford to buy her child food, can buy 2 separate bottles of children's medication, and that's how he ended up with both in his system? That's not reasonable. It's not reasonable. The children's medication has the same warnings. Do not use to make a child sleepy. Keep out of reach of children. Overdose warning. Contact poison control right away. A dose of children's diphenhydramine is just 1/4 of what an adult gets. And a dose of children's acetaminophen is less than 1/6 of what an adult gets. There is a liver warning on the children's bottle, and it says a max of 5 doses in 1 day. 5 doses in 1 day is less than what would be in a single dose of that adult sleep-inducing medication. That adult sleep-inducing medication that you know he was given shortly before his death. And Teresa lied about it. She lied about it. You heard her statement. I know something was wrong. She was explaining his symptoms. He wouldn't want to talk. He wouldn't want to get up. He just didn't want to do anything. He was not throwing up, like gagging, just lethargic, weak, and tired. This child didn't have food poisoning. Let's not forget that the defense's own medical expert, who's done over 400 autopsies of children, has never seen a child death from food poisoning. We all have had food poisoning. You are going to have vomit or diarrhea or both, and it's terrible. There is no second guessing when you have food poisoning. A child that isn't vomiting and doesn't have diarrhea did not die of food poisoning. You can check that off the list right now. Teresa lied about these drugs. She didn't admit to giving them for a reason. She wasn't honest with the police because she knew why William had died. She said, I gave him, I don't remember, it wasn't liquid, it was a lozenge. There aren't any lozenges with acetaminophen and diphenhydramine. If there had been, they would have been brought. A lozenge doesn't exist. She said, I think I gave him that. I don't know if I had any cough syrup. And then they asked her a bit later, it was mostly because it was the only thing I had to eat. but he wasn't coughing a lot, so I didn't have any cough syrup or anything like that. I didn't give him anything like that. I just thought he wasn't getting enough to eat. The most Teresa would admit to was that she gave him a lozenge to eat. A lozenge to eat. Teresa withheld medical treatment without a doubt. There is no conflict in the evidence. She said she knew what was wrong, or that she knew something was wrong, that she knew something was wrong for days. She just thought the child wasn't getting enough to eat. She said, I knew I should have done something. So this wasn't a situation where the child unexpectedly dies, and you're like, oh my God. She knew she should have done something, and she didn't do it. She knew she should have done something because William was sick enough that she recognized that. William died a preventable death. You heard that from all the experts, that he could have suffered from a toxic exposure to either or both of these drugs, that a death occurring as a result of a toxic exposure would have caused him to suffer, to feel pain, and that toxic exposure to both medications could be treated. It can be treated. And Teresa knew something was wrong, and she didn't do anything about it. That's what this case is about. It's about William and the failure of his mother to protect him. Why? Why did Teresa fail to protect William? You heard from Dr. Gonzalez, the overdose expert, that people don't take their children to the hospital when they have given them drugs in a non-therapeutic manner. When they either give them illegal drugs or they give them over-the-counter medications in a way they shouldn't have, they don't take them to the hospital because they'll get in trouble. That's why she didn't take him to the hospital, because she would get in trouble. You heard from Dr. Tice that it's difficult to fracture this area of the skull. You're more likely to fracture a little higher or a little lower, and that this type of fracture is common in abuse cases, the kind that William suffered, the fracture that had no evidence of animal activity around it. And Dr. Gonzalez told you it's not uncommon to see blunt force trauma in child overdose deaths. They often present together. Dr. Gallant told you that in unexpected death cases, the family is dying to know what happened. They're beating down the door. You know that. You don't need Dr. Gallant to tell you that. When a child dies unexpectedly, it is the most terrible thing in the world to a loving family. And that family wants answers. And they want to know why they have lost their loved one, their baby. But in fatal abuse cases, it doesn't hear from them very much, because they already know why the child died, because they're in cover-up mode, because they don't want to get in trouble. Dr. Turner herself, this expert that the defense had to go to Missouri for, they had to go find a paid doctor that they could fly in here from another state. For some reason, I'm still not entirely sure why. She agrees with the experts that his symptoms would be consistent with a toxic exposure to the medicines. She agrees we can't determine a cause of death. And Dr. Turner said she has never worked a case where a child has been abandoned, a child death, and they've been abandoned that wasn't related to abuse. Because it doesn't happen. She's been working for decades. Dr. Gallup has been working for decades. People don't abandon their dead children's bodies unless they have something to hide, unless they have something to cover up. After William has died, after his body is discovered in the woods in February, Teresa doesn't leave. She doesn't go home back to Charlotte. She stays here. You know she stayed here because on June the 23rd, William's 7th birthday, she goes to a DMV in Georgia and gets an identification card. That's her face on her 7-year-old's birthday that just 4 months prior was found decomposed in the woods, that the community is searching for. That's her face on the anniversary of his birth. By December, roughly December of 1999, Teresa has returned to Charlotte. And here begins some more cover-up. First, she lies to Ava about William, tells all sorts of stories about how he's with his father's family, godparent. Then she lies to William's father's family about William. And in 2002, you heard from Investigator McClendon that it was confirmed that there was a child support case between Teresa and her child's father, William Hamilton, after she knew he was dead. Teresa then moves to Alaska with her new husband, Laquise Black, in 2005 and continues lying. She was so bold as to find some teenage boy and put him on the phone with her husband and pretend to be William. Those are the lengths this woman will go to lie to people, to manipulate her circumstances. She then lied to Wanda in 2017. She doesn't just say William's alive and in Atlanta somewhere. He's got kids. Now he's got kids. This isn't someone who feels remorse. And then on February the 15th of 2022, she lied to the police. She lies to the police. She doesn't even mention she's ever lived in Georgia. She doesn't even mention she has a son. And it's not until they tell her they're from Georgia. Yeah, no, I do have a son, actually. And then we have to listen to all these lies about how she left him with some woman she met in Atlanta. The crocodile tears. He's dead? No! 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 It was all lies. All lies. And those tears were for herself. Those were tears for Teresa because she was scared she was in trouble. All that time that Teresa was lying and covering up what had happened to William, law enforcement never gave up. This child, while he may have been unidentified, had a special place in the hearts of this community, at the medical examiner's office. While he might not have had a special place in his mother's heart, at the medical examiner's office, they named him Dennis. And they pursued every lead they could, having artistic renderings done, having clay remodelings done, reaching out to the community. This child was never forgotten. And there's a reason that his case was so special to everyone involved. Because what happened to him was so touching. See, there's a very fundamental truth at play here that I don't have to tell any of you. And that's that people who love their children do not abandon them in the woods to rot and be feasted on by animals. It does not happen. Even if you believe that Teresa merely woke up and found her son dead beside her, the act of walking away, leaving him in that secluded wooded area where he was not found for almost 3 months, is concealing his death. That act alone is concealment. The defense would have you believe there needs to be some affirmative act. She needs to sprinkle him with pine straw. She needs to cover him with dirt. She needs to move his body. That's not what's required under the law. You have to find that she concealed his death, and that concealment prevented law enforcement from discovering what happened, and that is exactly what happened. She effectively concealed this death for almost 3 months because he was left in a secluded wooded area that people didn't go in. He was concealed, and law enforcement were hindered. By the time they got to him, his body was severely decomposed and much of the evidence was gone. Teresa was successful for a long time. She was able to hide the evidence and to muffle this child's voice. His ability to speak from the dead about what had happened to him. But William did speak. William spoke to all the angels in this case. The doctor who found the drugs in his body, the artist who created his likeness and broadcast it to the world so that hopefully someone would recognize him, and to Ava, his biggest angel of all, that woman who, when she realized he was leaving, grabbed hold of that child, stared him in the face, and repeated her name over and over, told him to repeat his, so that her face and her name would be seared into his memory, and he would never forget her, as he seared his own name and face into hers. And Ava did find him. William spoke one final time through that computer screen to Ava. And the case broke open. William was found and identified. He was given his name back. And now he has been speaking to each of you. In the course of this trial, William has been speaking to each of you. And the time has come for you to be his voice. The time has come for you to speak for William and to say what we all know, what we all feel deep in our hearts and in our guts. That Teresa Black is responsible for his death. That Teresa Black failed her child. It is time for justice. It is time to hold Teresa responsible and to tell her something that she already knows, that she has known for a very long time. And that's that she is guilty of each and every count. Thank you.
All right, ladies and gentlemen, it is 1:30.
That was good, right?
We're going to go ahead and break for lunch now for 1 hour. We'll be back here at 2:30, at which point I will give you the jury charge, which is
And then the sound went off.
the jury to begin the deliberations. Same rules remain in effect.
Sound going on and off. So basically they're going to have lunch break, which thankfully we've got perfect timing here because they're supposed to be back at 2:30 Eastern, which is in 3 minutes. So we can just skip right over lunch and then we can watch the jury instructions together and then they'll go off to deliberate. Rita says, amazing speech. Lady in Grey says, good closing arguments. It was good, right? I mean, I know some of it's still very emotional and she's talking about, you know, angels and emotions. I don't know if that appeals to all the jury members. But I think that timeline was really good. I was taking a whole bunch of notes because it was implied that he was found in the clothes that Ava saw him leaving, but the prosecutor said he was found in those clothes. So that and the timeline and exactly when he was pulled out of school and all of that was very interesting. So I've made my notes there for you guys. Let's just see. All right. So basically what I can do now is forward, just hold on, to the current time of the feed because they should be coming back any minute now. All right. So this is what we're seeing so far. With the sound is still on, so we'll just leave it like that for when they come back. They should be coming back in 2 minutes. See, that's why we start later. Isn't it nice? I like it. I like it a lot. I think the strategy helps a lot. Bunny said her statements are powerful. Thank you, Angel, for helping William find justice. And I totally get both sides of how everyone in chat is feeling. That some people feel like the state didn't prove murder, and other people are feeling guilty for everything. I mean, I'm a little bit on the fence myself. I'm actually a little worried about the jury. I think that's the thing. Unanimous to agree on all 6 charges. I think the jury might deliberate for quite some time. How about you? Sorry for the paper noises there. So count 1 is felony murder, and they said that would be causing death by committing a felony. Count 2 is cruelty to children, which they said it would be cruel or excessive physical or mental pain by not seeking medical treatment. That one, I think, in my opinion, that one was probably proven, right? Then count 3 is also felony murder, so it still causes death by committing a felony. Count 4 is cruelty to children, and that was about administering the substances, which would be the Tylenol and the Benadryl, in the supposed amounts that would result in those amounts being in his skeletal muscle. So that second count of cruelty to children would be about the substances, because that's what I scribbled down there. Count 5 is aggravated assault, and they say that would be assaulted with offensive weapon. Now the problem with that is we don't have proof of that, right? From what I've heard, wow, it could go either way. I don't know, man. I don't know how they're going to prove that one, because it could have been post-mortem or not. So there's that. And then the 6th charge, count 6, is concealment of the death of another. I think that was proven as well. So in my opinion, The cruelty to children charges, so count 2 and 4, and then concealment count 6. Those to me, I would, if I was on the jury, okay, those, I think that will be quite easy, I think, to reach a unanimous verdict. But felony murder count 1 and 3, as well as the aggravated assault, whew, that's going to be very difficult. Very difficult. Rob says, I think that the deliberation will last more than a day. So just so that you guys know, if you're not sure how we do it over here, I have already set up the next stream, which is for the verdict. And the reason we're not just going to sit here and wait and have a live stream going is because what happens then is the stream goes for 8 hours, 12 hours, and YouTube also continues to, they only store it for like 12 hours, right? My point is, then you're also not going to know because you won't get the notification, of course, unless you're on Patreon. Then you'll get that notification like verdict is in. But I would rather set up the stream as I have, and as soon as the verdict's in, then we get ready and we go live. And then you should get the notification either half an hour before, if I'm able to. If we get it immediately and I go live immediately, you'll get that notification. If we have a little bit of notice, which is a little unusual for a verdict, then you would get the notification half an hour before and when I go live. You should. If you subscribe, put all your notifications on, then, okay? Now let's see what Gypsy Moon said. My opinion, count 1, guilty. Count 2, guilty. Count 3, guilty. Count 4, guilty. Count 5, not guilty. Wait, count 5, not guilty. Okay, yes, and count 6, guilty. Okay, interesting. Daisy Love said felony murder can be because she committed other felonies and it caused the death of William. Any thoughts? I mean, it could be. Let me just quickly prepare our next little banner here, because that was, of course, I think it was a really good closing argument, especially from, I think the defense attorney did very well. But then I think, wow, the rebuttal from the state, that was really good as well, right? Okay, Forensic Fury says, what do you mean you're not on Patreon? Come on over, it's the best place. We've got a community chat, behind the scenes videos, podcast episodes, even though I'm not a podcaster, all of that, right? And we might do that, yes. I'm just talking now, so I can't do that and talk. When we're watching again, then I'll probably put a poll up like that, like how long do you think? I think they could take a while. So right now, Eastern time, there in Atlanta, Georgia, 2:33 p.m. Okay, so we've gone over the counts. The other thing that's interesting is that the state and the defense are, the state's saying that Teresa put a jacket over William's body, and then the defense is saying there was no jacket put over his body. And just based on the photos that I did not stream but did have a glance at, I didn't see that something was put over him. So I don't know why that's confusing, you know? And I do wish they had a like bullet point presentation with that full timeline. I think this was one of the best timelines presented. It's just unfortunate it's only now in closing arguments, but it's only been a 5-day trial so far, right? Okay. Linda says Patreon is the best in my opinion. Thank you so much. And it is the best form of support beyond, of course, PayPal. So if you are a member here, please consider checking out Patreon as well, because it's, you know, YouTube takes half of everything, and then the tax man takes the other half, pretty much. So Patreon is a great place to be, and it supports the work that I do a lot. So thank you so much. And now Forensic Fury said, yeah, that was all about trying to prove the concealment bit. Yes, but like, how can they at this point be like, you know, the state saying that a jacket was put like over him, and then the defense is saying there was no jacket? What? That should all be ironed out by now, right? Yeah, Luna says the jacket would be concealment. Sorry for this little background. I can actually take it off until we actually have something to look at, you know? Is the sound? Okay, the sound is not on. Good. So let me just put this little banner on because the state's rebuttal is now over. So there we go. Also, if you didn't know, the picture, the flowers next to William are actually Sweet William flowers. It's something that I learned yesterday. Some people already knew it. Okay, I didn't know that that's what they called. And Max Bang, who I think you're in chat now, Max Bang said that they will be planting Sweet William flowers in honor of William DaShawn Hamilton. And then Nurse Janet said earlier, or Nurse Jane said that the best time to plant them would be between May and June, if you're in the Northern Hemisphere, of course. So if you're going to be doing that, please make sure to use the hashtag William DaShawn Hamilton. Also, make sure to tag me if you are posting that on X, for example. My handle's TrueCrimeGizzler. And please email it to me as well. My email address is grizzlytruecrime@gmail.com. Okay? So, yes, Deb, we don't have a jury system. We have bench trials and the judge decides, which I like that. I do. Very different. Okay, so let's see what you guys are saying. Yeah, Sharon says, what do Fury and Willow think? Well, all they can think about is snacks, okay? They can't think straight unless they've had their snacks. All right. So, closing argument. Wait. Oh, yeah. The prosecutor said that Teresa never once said, I loved him, or that she loves him. We've never heard her say that. That's pretty scary. I know we've only seen those police interviews, but even when confronted with the information they had, there was never but I loved him so much. What do you mean he's dead? Or what, like, that was a good point as well, right? Forensic Fury said, I will never look at Timberlands the same, right? Okay, now let me just quickly check because I want to show you this little video quickly. Is it this one? I think it's this one. Wait. I don't think we've looked at this video before, did we? Sorry. I'm trying to find you a video of Ava. I don't know if we looked at that one, but there was two of them. Anyway, I want to show you that quickly, so just hold on 1 second. This here. And if we need to catch up, we will. Okay. It would be this one from the NCMEC. Okay, so let me move myself again. Like this. All right, so this is a video from the National Center for Missing and Exploited Children, and it features Ava, and then Angeline Hartman, the spokesperson, is also in this video. So let me show you.
This reconstruction image, created by the National Center for Missing and Exploited Children, is just one of many created over the last 2 decades as investigators in DeKalb County, Georgia, tried to identify a young child. He was found next to a cemetery on February 26, 1999. For 23 years, no one knew his name or where he came from until now.
Oh my word, it's so nice hearing Angeline's voice again. If you haven't heard her podcast, please check it out. It's always in every description box of this trial that I've covered. But listen to the 7 episodes on this case and her other episodes. They're really good. Her podcast is called Inside Crime, and it's her speaking now. She was the reporter with Fox at the time when this little boy's body was found and no one knew who he was. And she could just never forget this case. And it's because of her podcast and Ava seeing the National Center for Missing and Exploited Children art rendering and listening to the podcast that Ava called in the tip. Okay. Kim said, going to plant my sweet William seeds on June 23rd, William's birthday. That is amazing. Thank you so much for doing that. That is so sweet.
This is William DaShawn Hamilton. Investigators say he was 6 years old and he lived in Charlotte, North Carolina, more than 200 miles away from where he was found.
When I seen that picture, I just screamed, "Ah!" And tears just started. Because I knew that was him.
That's amazing still, that even the NCMEC, the art renderings they'd made like clay models, and, you know, over the years, they'd been working on this case, always, this cold case, right? And Ava had never stopped looking for William. And it was her daughter that said, look, you've been looking for him as if you were alive this whole time, you know? So looking for teens and looking for adults. But what if he didn't make it? What if he died? So maybe you should look into children who had died. And so that is what Ava started doing. And when she saw that art rendering, you saw that reaction there. Like, that's him. So it's just, this case is so special and so amazing because so many people, you know, were involved in bringing this case to trial today, 25 years later. So look here, one more time.
Ah! And tears just started. Because I knew that was him. It was no doubt. That was him.
This is Ava. We now know William's name because she had been actively searching for him for more than 20 years and finally found him.
Me and his mom sparked up a conversation and it went from there. He was everything to me because I wasn't a mother then. But we had good times. I loved him. I did a lot for him. I cooked for him. I took him his first bath. Taught him how to tie his shoes.
Ava says one day, William's mom suddenly decided to pack up and leave town with William.
I still want to know exactly why Teresa did that, because that is a big red flag. To just suddenly pack up, leave everyone and everything behind for what? And she told Ava it's for some guy, Mike, you know? Okay, the court's coming back on. I just want to finish this clip. This is Angeline Hartman, by the way, and her podcast is called Inside Crime.
Eventually, she came back here to Charlotte, but she didn't have William with her. Ava says she knew something wasn't right.
I got phone books from the library, from everywhere, Florida, Georgia, South Carolina. And I called and I called and I called every hospital, every agency that I could, but it was always a dead end. Every time the phone rung from the time she came back without him, I answered every call. Every call. If I missed it, I called it back. Every call I answered. Every call. Hoping and praying it was him or information saying that he was okay.
I cannot emphasize it enough that you did not stop. I mean, we're not just talking once a couple of times, once or twice a year.
Every day. Every day. 4, 6, 8, sometimes 12 hours a day. Sometimes I went to sleep with the phone and the computer on me, papers on me, papers in the bed, pens, every day. Every day. That was like my job.
Isn't it amazing though? I'm just like, I can watch this 20 more times, 100 more times, and I'm just always like, what? So amazing.
To find him.
When Ava finally found his image, she called the National Center for Missing and Exploited Children. Our team then followed up, researching, analyzing, trying to connect the pieces to help investigators track down his family. With DNA work provided by our partner, Bode Technology, William's identity was officially confirmed.
Justice has no time limit. When my team actually got going on this case, it only took that one tip, that one thread, and once they started pulling it, they're like, we got this. Now that we have an identity, we can follow all of the breadcrumbs, and they did, and here we are. And it is a truly memorable moment for William, really.
And now, William's mother, 45-year-old Teresa Bailey Black, has been arrested in Arizona. She faces 2 counts of felony murder, 2 counts of cruelty to children, 1 count of aggravated assault, and 1 count of concealing the death of another. As investigators continue to put the pieces together about the time surrounding William's murder in 1999, they're asking anyone who knew William or his mother Teresa to please call the DeKalb County District Attorney's Office Cold Case Tip Line.
And here is, sorry, I just want to pause there because, I mean, if you have any information, maybe you could still call it. You never know.
For Ava, her long search for William is finally over.
This was God's plan, maybe give him a love and attention that he needed, and to be the one to pick up these pieces for him after she scattered them and thought they couldn't be put together. Maybe that was my purpose of coming into his life, to make sure that once his life was taken, that I would get him justice, and I have.
Amazing, right? I've also got the link for the National Center for Missing and Exploited Children in the link if you do want to check that out or donate to them or something like that. Okay, let me go fetch the court feed for us because the jury instructions are happening. I'll link that clip that I just showed you as well. Just stand by. Just want to quickly go back a second because they're busy giving jury instructions right now. So here we go. And let's just see when they came back right there.
Yep, you got everybody? Okay. Yep. All right, ladies and gentlemen, I am about to read to you the jury charge, which is a compilation of the laws that apply to this particular case. It's important that you pay close attention to this. I am going to send a written copy back with you to refer to later, so don't feel like you have to write down every word. So just listen, and then you'll be able to refer back to it when you are, during the course of your deliberations. All right, you are considering the case of the state of Georgia versus Teresa Black. The grand jury has indicted the defendant with the offenses of felony murder, 2 counts, cruelty to children, 2 counts, aggravated assault, and concealing the death of another. The indictment reads as follows. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of felony murder in violation of OCGA 16-5-1 paragraph C for the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury. Well, in the
I'm just quickly pausing. I just want to make sure it's distorting just a little bit. So I just want to take this boost off if I can. I think the judge is speaking loud enough. We can hear it loud and clear. Okay. So it should be good now.
The commission of the offense of cruelty to children, a felony, as alleged in count 2 of this indictment, did cause the death of William Hamilton, a human being, by failing to seek medical treatment for William Hamilton. Count 2, cruelty to children. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of cruelty to children, OCGA 16-5-70 paragraph A, for that the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, did maliciously cause William Hamilton, her child, cruel or excessive physical or mental pain by failing to seek medical treatment for William Hamilton. Count 3, felony murder. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of felony murder in violation of OCGA 16-5-1 paragraph C for the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, while in the commission of the offense of cruelty to children, a felony, as alleged in count 4, did cause the death of William Hamilton, a human being, by administering a substance or substances containing diphenhydramine and acetaminophen to William Hamilton. Count 4, cruelty to children. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of cruelty to children, OCGA 16-5-70 paragraph A, for that the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, did maliciously cause William Hamilton, her child, cruel or excessive physical or mental pain by administering a substance or substances containing diphenhydramine and acetaminophen to William Hamilton. Count 5, aggravated assault. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of aggravated assault in violation of OCGA 16-5-21A for the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, did make an assault upon the person of William Hamilton with an object unknown to the grand jury, which when used offensively against a person is likely to result in serious bodily injury, and did result in serious bodily injury by striking said victim in the head. Count 6, concealing the death of another. The grand jurors aforesaid, in the name of and on behalf of the citizens of the state of Georgia, charge and accuse Teresa Black with the offense of concealing the death of another in violation of OCGA 16-10-31 for the said accused person in the county of DeKalb and state of Georgia on about and between December 1, 1998 and February 26, 1999, the exact date being unknown in the grand jury, did unlawfully conceal the death of William Hamilton, which hindered the discovery of whether William Hamilton was unlawfully killed by leaving the body of William Hamilton in a wooded area and lying about his whereabouts, contrary to the laws of said state, the good order, peace, and dignity thereof. Now, the defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor, or her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of a crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, the stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, and matters of which the court has taken judicial notice. Evidence does not include the indictment, the plea of not guilty, the opening or closing statements of the attorneys, or any questions asked by the attorneys. The parties have entered into stipulations that have been approved by the court about the following facts. 1. On January 14, 2021, skeletal muscle from the child's remains was submitted to Bode Technology for DNA typing, and a DNA profile was obtained. The DNA profile for the child was compared to the known DNA profile of William Harris Hamilton, and the alleged child could not be excluded as the possible biological child of William Harris Hamilton. The results provided moderate support for relatedness. Stipulation number 2, an aluminum can labeled very fine fruit punch recovered near the child's remains was submitted to NMS labs on April 12, 2022 for toxicological screening. The testing did not identify the presence of any known substances. 3, the Smithfield Elementary records for William DaShawn Hamilton, date of birth 6/23/92, are authentic and admissible in evidence. 4, the map labeled 2918 Clifton Church Road Southeast is authentic and admissible in evidence. 5, the witness, William Hamilton Sr., was unavailable from October 14, 1998 until March 2, 1999. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all of the decisions based on the evidence in this case. Is the next paragraph applicable?
Yeah, yeah.
I didn't think so. Okay, we'll take that one out. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness or by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of this case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of her constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of his or her rights as discussed below. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant has a right to remain silent. 2, if the defendant chose not to remain silent, anything she said, wrote, or signed could be used as evidence against her in court. The defendant had a right to consult with a lawyer before any questioning and to have the lawyer present with her at all times during questioning. And 4, if the defendant did not have money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questioning. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict, except for the purposes of attacking the credibility of the witness or impeachment. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue or purpose for which the evidence is limited and not for any other purpose. Evidence of prior difficulties between the defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of the identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident; 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident; 3, the possibility of mistaken identity; 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have; 5, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator; and 6, the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. Now, evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Now, the defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of the state in which there is a joint operation of an act and intention. When a count of an indictment charges that the defendant committed a crime in more than one way, you may convict her if the evidence shows that the crime was committed in any one of the ways charged. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but simply means the intention to commit the act that is prohibited by statute. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Cruelty to children is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of cruelty to children, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For concealing the death of another, the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. For cruelty to children of the first degree, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice, in this context, means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. The law generally provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, meaning that the crime was committed in DeKalb County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Now, by no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. At the beginning of this trial, you took an oath to render a true verdict according to the law given you in this charge and the opinion you entertained of the evidence produced to you to the best of your skill and knowledge, without favor or affection to either party. This means that your verdict should be a true verdict based upon your opinion of the evidence according to the law given you in this charge. You are not to speculate upon the consequences of your verdict or make assumptions about any other matter which has not been presented as evidence in this case. If you do, you are not only violating your oath as jurors, but you may be relying upon assumptions which are untrue, unfounded, and could cause your verdict to have consequences which are the very opposite of your intentions. Do not be concerned about any matter which is not in evidence, and do not be concerned about whether you agree or disagree with the law if I've instructed you. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it's wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. As to each count, if, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant about and between December 1, 1998 and February 26, 1999, the exact date being unknown, commit the offenses as alleged in each count of the indictment, then you'd be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. You must make the decision as to each count separately. As to each count, if you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Whatever your verdict is, it must be unanimous, that is agreed to by all of you. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. All right, now, before I send you back to the jury room to begin your deliberations, I do have some bad news, and that is this case and all cases can only be decided by 12 jurors. We have 15 of you. We do that on purpose because, God forbid, in the event of a true emergency, if we didn't have alternate jurors built into the panel, we'd have to start this trial all over again. So, and we've had, I mean, that's happened before, where we've had to replace jurors with alternate jurors because somebody got sick, somebody got COVID, a family member died. I mean, just, anyway. So, unfortunately, in this instance, this is when you have to remember your juror numbers. Jurors 45, 49, and 50. Where are you guys? I'm sorry, you are the alternates. However, I can't excuse you yet because the jury is still deliberating. If something were to come up during the deliberations, we would have to call upon one of you to replace the juror who had the issue, and then you'd have to start your deliberations again. So I cannot excuse you yet, but you do not get to go back to the jury with the rest of the jurors. I'm sorry. And it probably feels like Christmas morning and you have no presents to open. So I apologize. But again, there have been instances where something has happened, and because this trial slated for 2 weeks, it was over a weekend, and you just never know what's going to happen. All right, so with that, the 12 of you are going to go back to the jury room. The alternates can go back and get whatever items they have in there. And we have a separate room for you downstairs that you can hang out in. The alternates, I don't want you to discuss the case with each other because we very well may need to replace you with, or replace the juror with you. So just bear with me a little bit longer. And the rest of you, you may go ahead and select the foreperson, but please do not begin your deliberations until you receive all of the exhibits. And it's only those exhibits that are allowed to go back with the jury. The indictment, the verdict form, and a copy of the charge. If any questions come up during your deliberations, first of all, if you ask me, what did witness so-and-so say about such and such, I'm going to tell you, you have to rely on your collective recollection of the testimony. There is no transcript available to you. I can't replay it. I can't comment on it. So you're going to have to remember what the witnesses testified about. But if you have a question of the law, if you want to take a break, it's about 3:15. I'll let you deliberate for a couple hours tonight, and then we can come back in the morning if you're not done. We have all week slotted for this case, so there's no rush. I don't want to rush anybody. So if you do have a question that comes up about the charge or the form of the verdict or something, write it down on a piece of paper. Buzz, there's a light back there that you push the button and it'll get the deputy's attention. They'll bring it to me and I'll show it to the parties and we'll discuss whether or not we can address the question. Okay? All right, the 12 of you may go back. Well, all of you go back. The alternates, grab your items and the deputy will escort you to the alternate waiting room.
Okay, so they go at 3:15. I'm writing it down. January 9th, Eastern Time, 3:15 p.m. Okay, so that we can calculate how long it took by the time they come back. I mean, I could be wrong, but in my opinion, yeah, this could take till Friday. How do we know? Huh? Like, to have a unanimous verdict on, they have to come back with guilty or not guilty. And they first have to decide on all of them. Count 1, 2, 3, 4, 5, and 6. Now, I did look up how long her sentencing could be. Just hold on one second. I'll put the sound back on here.
And
yeah,
I think the only other change she made was that where it said she or he, she just changed.
I'll tell you now.
She. Do you all want to take a look at that first? And that's
let's listen to
charge,
this.
The verdict form, and the this is the old.
I'll just quickly pause it and, we'll watch some of this fluff afterwards. So it will be, wait, let me just see. Okay, so for felony murder in Georgia, they say the maximum sentence could be life without parole. And of course, she's facing 2 counts of felony murder. So the maximum could be life without parole from what I've researched. Remember, I'm not a lawyer, okay? And then aggravated assault would have to be more than 1 year, but less than 20 years, okay? Concealment would be a $1,000 to $5,000 fine, and the cruelty to children, she's got 2 counts of that, would be between 5 and 20 years each. So, I mean, it could be LWOP, it could be acquitted. At this point, I don't know. It's gonna be tough for this jury. I really think so. If they have to agree on all 6 unanimously, oh my goodness, that's gonna be tough, because I don't know if the felony murder was proven. I know we're all completely heartbroken about William being left the way that he was and the way that he likely died. Felony murder, I don't know if the whole jury, if all 12 of them are going to agree on that. I wonder, right? I wonder. And yeah, this could take a while. And Linda Wolf says 12 people, 6 counts, unanimous, might take a while. And the judge said, we've got all week, the rest of the week scheduled for this. So I'm guessing that's also like, hey, you've got until the end of the week and then wrap it up, right? Otherwise, it'll be a hung jury. If they can't have a unanimous verdict, it's going to be a hung jury, which then is usually a mistrial, and they'd have to reschedule a whole new one. Let's hope that doesn't happen. I'm worried about that. But if they do come back with a verdict, I'm not even confident of what that would be. You know, like, is it going to be guilty or not guilty? Ooh, this is very hectic. We don't know. We don't have a crystal ball. So let's just listen to some of this fluff and then I'll talk a bit more. Yeah, Joy says the felony murder charge worries me.
H in her first name. I don't think it really matters.
Yeah, Tracy, concealing a body is only a fine? Mm-hmm. Seems to be. In Georgia, when I looked it up, $1,000 to $5,000 fine. I don't know. That was just a quick search, so quite something, huh? Okay. Are they doing anything else? Yeah, a little bit more.
All the exhibits are ready to go?
Yes, Your Honor, would you like us to put on the record what we agreed
Yes.
does not go back?
Yes.
Very wet.
Go ahead.
I can barely hear them now.
Exhibit 37, which is the AJC
Sorry.
article. Exhibit 68, it can go back, but it's the unredacted copy. We're going to send the redacted since they already know.
I don't think they're being timed, Linda. The judges said they've got it, the trial
79,
scheduled.
the CV for Dr. Jackson.
They said they've got it scheduled until Friday. So I don't know if they would, I'm sure they can't just go on and on for years and years. They would have to, for every trial, be some sort of deadline for it to then be either, okay, a hung jury or what is the verdict? And if you're referring to the time that I wrote down that they started, we do that, right? So that we can count how long it's been. Okay.
75, the NMS Labs toxicology report. 58, the medical examiner's report. 66, the amended anthropological report.
Let's go quicker.
69, DNA report for STR testing. 70, DNA report for mitochondrial testing.
Yes.
65, the anthropological report of Dr. Tice. Defenses 1, the anthropological report of the University of South Florida from 2013. We are sending back the flash drive and discs that are Defenses Exhibit 2, States Exhibit 11, and States 68A, but of course with nothing to.
I thought I told them that if they wanted to rewatch that, they could, but, okay. Well, no, Darren, hold on.
I was wondering too,
Do you want
John.
us to let them know they can rewatch it?
I believe I did in my opening, but.
I think if they want to watch it, they have the disc. I think it'd be enough to let them know.
Well, the deputy said he would tell them, but I don't want him to have any communication with the jury unless you all are in agreement.
I think it's possible that some of the jury may have gotten confused when you said, you want
That, I said there's no transcript of the email. Okay. Why don't we do this? Let's send a note back. I don't want to bring them back out here that says if they want to rewatch, what were the exhibits?
States Exhibit 11 and 68A, Defense Exhibit 2.
To rewatch States Exhibit, which ones?
11, 68A, and Defense 2.
Or
Yes, Linda, let's do that. If only we could teleport to that, huh? To the verdict. That would be so cool.
please let us know so we can bring you back out to the courtroom. As there is no mechanism, no method of doing that in the jury room. Okay, take a look at this. You're right, I did say I can't replay anything for you, so that is, all right, add these to, put these with the exhibits. Do we have a folder, like folder for the verdict form? Oh, you got it, Diane has it, just for the verdict.
I just want to see this so we don't miss something.
All right. Okay, that's everything. We'll be in recess until we get a question or a verdict.
Judge, just tendering for the record, defense 3, my proposed jury charge that I'm concealing.
Unconcealing, okay, yes, that's the non-pattern charge.
Correct.
Okay, thank you.
It's not going back.
All right, I'll be in office. Don't go too far, because if they have questions, they usually have them earlier.
Yeah.
So just stick around, we're ready.
Okay, so we've seen everything from day 5 today now. So we saw the closing arguments from the state, then from the defense, then we saw the rebuttal from the state, and now we've also watched the jury instructions. So the jury is deliberating. They have to reach a unanimous verdict on all 6 counts. That would be guilty or not guilty. They could also be deadlocked, and that takes more time. I don't think there's a finish line by Friday at 5. I think they can go on, maybe over the weekend. We'll have to see, how long that all takes, or it could be eventually a hung jury. There's many outcomes here, and I don't know which one it's going to be. Sometimes you feel like, okay, I think it could be this. I don't know. In this case, this is very hectic. Also, the little evidence they had to go on, of course, from February 26th of 1999. Wow. Yeah. Mrs. Melissa says, exactly. Court is sometimes about the fluff. We don't want to miss something important there, right? Okay. So if there's a jury question that comes up, of course, I'm not going to be live because I prepared a verdict, like when the verdict's in stream. So I will be monitoring. So I'm going to be sleeping with one eye open. Probably not going to sleep at all. It's already 9:30 p.m. here in the Netherlands, right? So I'm 6 hours ahead of Eastern time. So even if they went home at whatever time it was today, 5 or 6 or 8, and that's like 2 or 4 in the morning for me. But I'll be monitoring. And if there are questions, I'll write them down. And then when we meet again, or if you see a question and you want to send it to me, you can send it to me on email, grizzlytruecrime@gmail.com. Then tell me what the question was and what the answer was. If you saw that, maybe I miss it. I mean, I'm not superhuman. I'm going to try to stay awake for all this, but send it to me if you have it, right? Or on X, my handle is @truecrimegizela. You can send me a direct message there. Those are 2 ways. I think email's best though. Okay, I don't mind if, 50 people email me the question because I would rather not miss the question. So there might be jury questions. I'm glad that the jury, of course, can ask questions. We see that always. Sometimes we've seen in the trials where the jury can ask questions during the trial. That's been quite nice to see as well. Okay, so, wow, 2 counts of felony murder, 2 counts of cruelty to children, aggravated assault, and concealing the death of another. That is what they're going to have to deliberate on now. I feel sorry for those alternate jurors who have to stay, but they have to sit in another room and won't be deliberating. So if you think, damn, this is taking long, I'm getting tired, just think of them. Shame, those poor alternates are like, oh man, in some other room. Hope the coffee's good, right? So at the end of the day, I said this from the beginning, I'm just so glad that William, because of Ava, got his name back. That is just amazing after 23 years that he was finally identified, right? Okay. Yeah, exactly. Carrie said, she said they deliberate for a couple of hours and then come back in the morning so you can get some sleep. Imagine the shock if they go there for a couple of hours and come back with a verdict. We'll all be like, wait, what? You better email me and wake me up, okay? I'll get those rude emails and tagging me on X saying, wake up, Gisela, like we did during the Cavalcante manhunt. Do you remember that? All hours of the night, people are like, wake up, Gisela. I'm like, for hours and weeks, all the time, just stay awake. So, yeah, I really enjoyed watching today with you. It was very interesting to see those closing arguments. I did make some notes, which I'll look if there's anything to discuss afterwards. One of the things I wrote down was, I think it was Marilise asked, where was William's coat? If they left in December, where was his coat? And then it made me think, well, where is all these other stuff? Then I thought of the guy, the witness who said he dropped them off at the bus stop, right? And said that he saw like a tote bag, but not really a bag for William. Even that to me would be like, whew. Just hold on quickly. Hold on. Mr. Grizzly says hi. Okay. So that makes me worried because even if she took clothes of his width, right, and like a little toothbrush and things for him, well, where's that stuff? Where is that? Ooh, that's a concerning thought, right? Okay. So if there's anything else to bring to you, of course, we'll meet again. Please make sure that you are subscribed with your notifications on. And then if you're on Patreon, you know you'll get an email immediately. You'll get that notification, or on the Patreon app, you'll get a notification if you've got the notification set to on as soon as I'm going live when I hear that the verdict is in. So do bother me because the time zone is not in my favor, okay? Send me emails if you hear or see that the verdict is in. You can tag me on X, you can send me messages, whatever, okay? I give you permission to bother me for this one. Okay, so Marilee's, yeah, said, oh, that's even worse. Yeah, and hi, Mr. Grizzly. Yeah, that's a bad thought. And I'm pretty shocked at the timeline because I think I have to go rewatch Ava's testimony again as well. Because I thought, I had in my mind that they'd left somewhere around June of 98 and then that Teresa had returned like in December. Isn't that what the timeline was? And today the state's rebuttal just confused me a bit with the timeline. I'm like, wait, what? So I got to look at that again and just try to make bullet points for all that. Hopefully it'll make sense. So if you do want to rewatch the testimonies and you want to support my channel, please rewatch our live stream replays. It's all time stamped for you. Day 1, 2, 3, 4, and of course I'll do it day 5 as well for you. So you can easily just go to day 1 and look in the pinned comments or the description box and you'll see I'll write there Ava's testimony, right? And you can just go and rewatch that. So thank you so much, everyone. It's been nice to watch it with you, and I'll be keeping an eye on all of this. I'm sure you will as well. Janet says jellyfish. Yeah, jellyfish. And they both have the same reaction, Janet. I've never said if Willow reacts the same way. It's very funny. So if you want to see more of that, Patreon is the place. Okay, yeah, exactly. Marilee says she pulled him out of school 12/190. That I do know. That I'm aware of. But exactly when Teresa and William left North Carolina to go to Atlanta, Georgia, that one was a little confusing today. Okay, so I'll see you very soon, all right? And of course, we're following many cases. I mean, Jessie Kershevsky's got her hearing coming up on Friday as well. That's from the eyedrop murder trial. Remember that one? Yeah, there's a hearing to hear now feedback about what they investigated with that letter. Those letters, I think that's on Friday. All sorts of things. All right, so thank you, mods. Really appreciate everything you do, and I will see you all very soon again. Okay, bye.